Good morning, good morning, good morning, amazing law nerds, and depending when and where you're watching, good afternoon, good evening, good night, good early morning, replay crew. As always, everything is time stamped down below. We have lots to cover today. It's a rare Friday stream. Happy Friday. It's July 31st. I can't believe it. How are we already here? I don't know. To everyone who is going to Allentown this weekend or watching Allentown on Flow Marching this weekend, I will be watching along with you. Happy Allentown weekend. We are in a very busy final stretch for EDB. We will talk about that later, but today we are going back to court with Judge M. So we're going to be flying to Utah, but we have a few things we need to talk about before we get to Utah. Utah, give me two. Well, we were supposed to have two hearings today, and that's not exactly how the day is going to pan out now, is it? No, it's not. So buckle up, law nerds. We've got a lot to talk about. I'm going to roll the intro. We're going to talk about a hearing, not a hearing. We're going to talk about an order from the court from yesterday. Then we're going to go to court for the hearing today. And then we have a few other things to talk about. So, law nerds, are you ready to get into it? On a rare Friday stream, it's good to see everybody. I know. Y'all, it's Friday. It's Friday. It's going to be amazing. Let's roll the intro. Then we're going to go to court. Let's go. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. So yesterday, as I was getting ready for how the hearings were all going to break down today, and I told you that I was not sure exactly what was going to happen with the restitution hearing when we saw the filing for the restitution hearing and the state asking for over $1.3 million in restitution to two different insurance companies. Well, at the end of the day yesterday, and remember, just as a road so far, as an awkward road so far, but as a road so far, I wasn't sure this restitution hearing was going to take place on Friday because we were waiting to see what the reviewing court would say about whether Judge M had to be recused from this hearing or not. And as I was saying to y'all, if they don't rule before Friday, then this is going to get continued. And then, whoa, that was on the docket as I in real time opened the docket. I really didn't expect to see anything. It was just like at least I can say I checked. And then that ruling was there. And oh boy, was that a lot. That I'm still a little shook. The judge was just like, and let me tell you what. And I'm like, yes, you did tell us what, Your Honor. Thank you. So then, knowing that there was a status conference today and the restitution hearing, I was just like, I'm not quite sure what's going to happen. Well, the judge answered it for us with this order that came down yesterday afternoon. Emily, you made a pouty face. I did make a pouty face. Why? Because I am ready for this restitution hearing, because I want to see Judge M and Lewis and Nestor all in the same room again. I want them all in the same room again. I am ready. Everybody in one room. And that's not what's happening. Let's look at what Judge M did. This is from July 30th, yesterday. Ruling continuing restitution hearing. Boo! All of you said it out loud. Don't worry, we're still going to court today. There's another hearing that we're going to. Boo! Like the bar takers in the state of Washington. Boo! This matter is set for a restitution hearing on July 31st, 2026. The state filed its motion for restitution on July 23rd, 2026. The defendant's deadline to respond to the motion is August 6th. unless extended by stipulation of the parties or by order of the court. In light of the foregoing, the court hereby continues the restitution hearing in this matter to August 28th, 2026 at 1:30 p.m. Boo! However, at least it wasn't continued until while I was in Indianapolis, so that was great. Also, the defense didn't ask for a continuance. The state filed their restitution hearing, their restitution motion late. So August. I know, chat's just like, but I want this one. Okay, when I saw this motion, can I spoiler real quick? Chat, it's a Friday, it's between friends. Can I spoiler real quick? When I saw this, my level of disappointment was high. And here's the decision that was made. A, we're still going to court today because there's still a hearing on the financial case, and there has not been a hearing technically on that case yet, on all the fraud. And if you read the description of today's video, I was prepping that description with my self-appointed co-host. And so the description was dictated by my self-appointed co-host. And then do you know what I decided? Because we have a little bit of time, we're going to go take a look at the few of the sidebars. And we're going to find out exactly why Judge M told Nestor to slow her roll, because it's in their motion for new trial. And we have not looked at that sidebar yet. And I still do not know why Judge M told Nestor to slow her roll. So we're going to go take a look at a few of the sidebars that are quoted in the motion for new trial today instead. That's what we're going to do. We're going to look, it's our time. I'm here. You're here. We were ready for some tea. It's our time. So we're going to go do a few of the sidebars instead. So hopefully that will work with y'all, because I very much wanted to see Nestor and Lewis being like, "Good morning, Your Honor." And that's not going to happen. But there's a footnote on page 2 that apparently the judge told Miss Nestor to slow her roll. And we have not gotten to look at what that was for because we just haven't had time yet. So I'm sorry to say that this will not be the only thing. This continuance will not be the only thing that disappoints you today. There are other things that might be unsatisfactory today, but hopefully the sidebars aren't one of them, because I have not seen those yet. And remember, in that exchange where Lewis said that the judge told her to pause, there was that massive sidebar before, and then Lewis accused the judge of changing his ruling. We're going to take a look back at the video, and then we're going to take a look at that sidebar as well. So we're going to do that from the footnotes. So I've got you, but I'm also here to tell you, spoilers, that will not be the only thing that's disappointing today. I will see how we feel when we go to court. All right. With that, are we ready to talk about what happened next? So this is in the murder case. Remember, with Kouri Richins, there is a murder case that is now in its kind of post-trial phase. We've still got that motion for new trial pending. We have a restitution hearing pending. I'm interested to see what the defense says about this. I'm interested to see if the prosecution supplements this at all now that they have a little bit more time, though I think they did have plenty of time. I am ready to see what happens in the civil cases as well. My brain was moving faster than my mouth because Friday, but I'm interested to see what is happening in the civil cases. There is a hearing set in one of the civil cases that Kouri Richins still doesn't have a lawyer for. So she might be arguing that hearing pro per in October. So I am keeping an eye on the civil cases as well. Remember, when I say civil cases, there is the estate case, there is a trust case that is the probate side of it. But then there is Kouri sued the estate. And when I say estate, Kouri versus the estate, I mean the estate and trust together. But when those are getting probated, they're a little separate. Potato, potato for our purposes, but just to be technically accurate. So Kouri sued the estate at writ large. The estate sued Kouri and her mom and brother. That's still an active litigation. So those are the two main ones, like Kouri versus the estate and the estate versus Kouri. Kouri versus the estate's not going to go very far because the court in one of the civil cases has already found a disqualifying homicide. So when Kouri's like, I should get half the house, you can't. You can't. So with that, there is a hearing set for October. Kouri still doesn't have lawyers in any of those civil cases. So she is going to, show up on WebEx from prison to argue why she should get Eric Richins' assets instead of them going into a trust for her children? Well, Kouri, bold strategy. We're gonna keep an eye on those bold strategies. So there are hearings coming up in these civil cases as well. And just because the court found that Kouri had committed a disqualifying homicide does not mean that those civil cases are just done, because some of those civil cases is Kouri suing, and some of those civil cases is the estate trying to get money back from Kouri and where Kouri might have dispersed it. Mom and brother are both being sued in that case. So we have lots that's going to happen in the civil cases. And then we have the fraud case. And Griffin, being a middle schooler, said, imagine having a fraud case. Sounds like a skill issue. And I'm like, Griffin, what do you mean? And he said, well, if you were good at fraud, you wouldn't get caught. And if you were good at life, you wouldn't need fraud. And I was just like, well, first of all, fraud doesn't work the way it does in TV. Griffin is starting his journey with Supernatural. And season 1 of Supernatural, they do talk about credit card fraud a bit. And so Griffin is watching like fraud through the lens of Sam and Dean, which I had to remind him is not necessarily the reality of how fraud works. But Griffin is just like, I mean, if you're good at fraud. I'm keeping this, by the way. I'm keeping this now. If you're good at fraud, you don't get caught. And if you're good at life, you don't need fraud. And that's a little bit of Griffin wisdom, but that's why the description today says Kouri Richins is back in court today for a skill issue. So from my 14-year-old, that's how he perceives today's court hearing. So we are going to court in the fraud case. If you have not heard me talk about the fraud case for Kouri Richins, just throw one in the chat so I know how much of a road so far to give on the fraud case, because I for those of you that are well familiar with the fraud case, I do not want to overburden you with a super long road so far. But for those of you who are like, remind me again, I don't want to undersell. Okay, there's a good few of you that are not familiar with the fraud case. Fair enough. The fraud case is a lot more in addition to what we saw in the murder case. So let's do a bit of a road so far before we go to court. The fraud case has 26 charges. Charges 1 through 5 are mortgage fraud on different days. So different instances of mortgage fraud, counts 1 through 5. Counts 6 through 10 are forgery on different days that line up essentially with the mortgage fraud. So it's like mortgage fraud, June 29th, forgery, June 29th. Those are different charges, but same continuing pattern of behavior. We have counts 11 through 17 issuing a bad check. You can't just do that. You can't just write checks hoping for some kind of TikTok infinite money glitch and being like, but the money's there before the check actually clears the other bank. No. It's fraud. That's fraud. The way that Gen Z will literally repackage everything, though it seems that one of my favorite millennial hairstyles might be coming back, and it's gonna be back. But Gen Z tends to repackage things. And so Gen Z repackaged check fraud because I don't think they grew up ever knowing what checks were, but they repackaged check fraud and were like, look, if you deposit a check and then the bank lets you immediately withdraw it, it's free money. No, it's not. No, it's not free money. It's fraud, because they think that window of time between the check hitting one account before it clears the other account is just wibbly wobbly and timey-wimey. So no, that's check fraud. It doesn't need to be repackaged as a money glitch on the internet. No, it's just, God, we really aren't teaching kids about checks these days when they're like, it's a money glitch. No, it's fraud. And then counts 18 through 24 are money laundering. Because, I mean, if we're doing bad checks and we're moving money from here to there and there to here, it's money laundering. And then we have a count of communications fraud, which is essentially wire fraud, but the state level, and pattern of unlawful activity, which is not quite a RICO, but kind of, it is this ongoing, like you didn't just start doing this. Blake said, Gen Z started in 1997. Okay, do I mean to be yelling at Gen Alpha? Do we need to go down one? Yes, Gen Alpha. Gen Alpha repackaging things. It's fair. So then the last one is pattern of unlawful activity. Wrong generation. Fair enough. That's Blake. That's fair enough. Thank you. Blake is like, wrong generation. No, 97. I know. Emily, kids born after you went to high school. I know. It's hard for me to wrap my head around too. Let's take a look real quick, just as a reminder, because today's court hearing is quick. We're going to take a look real fast at some of the tea in the fraud prosecution information. So for those of you that are like, what was she doing? We're going to take a quick refresher and look at what is alleged in the information of the fraud case. And then we'll go to court with Judge M. And then I'll tell you a little story about court this morning with Judge M. Good. I think it's time now that we are getting into court to fly to Utah. And it's time for a little Friday. Let me know where you're coming in from, what you're drinking. Let's fly to court, shall we? Utah. Give me two. All righty. Let's take a look. We're going to have lots of water today. Let's take a look at the information. I went through an overview of the charges. I'm not going to redo the overview of the charges. They are just the different day and date. We're going to scroll until we get to the T. However, I remember how long this is. We've got pages of indictment. There will be parts that we will skip over, but let's see, up to page 18. So when we're looking at the narrative of the information, it is page, 10 pages long, 11 pages long. We are going from page 7 to 18. There will be parts we will skip over. We did cover this line by line about a year ago, a little more than a year ago when this was filed. Defendant met Eric Richins in 2009 while she was working as a cashier at Home Depot. They had a child in 2012, married in 2013. Oh, their oldest was born the same year as Griffin. So their oldest can also say skill issue. Sounds like a skill issue. Though in this circumstance, it's probably not going to happen, but yeah, same. At the time of the marriage, Eric Richins and his business partner owned a successful stonemasonry business. These are facts that we know. Skipping to the next paragraph, in early 2019, defendant used a power of attorney to obtain a $250,000 home equity line of credit. Like everything starts to umbrella from this HELOC. So a $250,000 home equity line of credit on Eric Richins' premarital home without his knowledge. The reason they said premarital is because this was his separate property. This indicates legally this is separate property of his. He is the one on the mortgage. He is the one who owns the home, not a joint tenant with Kouri. They don't own it together. His premarital home. On April 26, 2019, the defendant formed K. Richins Realty, LLC, for the purpose of, quote, selling/buying real estate. Defendant was the sole member of that company. Defendant used proceeds from the HELOC to fund the realty company and hard money loans to finance its ongoing operations. Her husband did not agree to take out money on the home and invest it into her business. She just took it. This was a full ask forgiveness situation. Don't do that in a marriage. That's gonna breach trust real big. But Emily, it's really too little, too late. That's gonna breach trust real big. Eric Richins first learned of the HELOC in October 2020. The secret origination and continued existence of the HELOC was a source of tension between defendant and Eric Richins. The defendant informed Eric that she would repay the loan and led Eric to believe that she had repaid it. The HELOC was not paid off on the day that Eric Richins was murdered. They say of Eric Richins' death, this was filed before she was convicted. That's appropriate. On October 13th, 2020, Eric Richins consulted an estate planning lawyer. We saw this testimony in the trial. Eric wanted to put money away to protect his children. And they say that he did this, quote, from recently discovered and ongoing abuse and misuse of his finances by the defendant, and to protect his 3 children in the long term and ensuring that the defendant would never be able to manage his property after his death. On November 3rd, Eric Richins executed several estate planning instruments. And then Eric removed the defendant as the beneficiary from a $500,000 New York life insurance company policy on his life and designated the trust as the beneficiary. The defendant did not understand this estate plan until after Eric's death. In the 5 months prior to Eric's death, Kouri Richins Realty realized $170,000 in revenue, while its monthly debt servicing exceeded $250,000. Look, I don't know how this doesn't make somebody stay awake all night long, but again, when you are looking at fraud defendants, they are in fact built different, but not in a good way. They are built different in that this shit doesn't bother them because they think they're entitled to it. And with all fraud defendants, and I worked a lot of fraud cases, with all fraud defendants, there is a through line of like, the world owes it to me. It'll be fine. You owe it to me. I'll be good. What's wrong with y'all? They think they've rolled like a nat 20 for charisma. Some of them have, but there are still consequences. In the 5 months prior to Eric Richins' death, Kouri Richins Realty realized $170,000 in revenue. Its monthly debt servicing exceeded $250,000. It borrowed from over 25 lenders to support itself and service its debt obligations. I really envision this period of time where Kouri is like Unikitty, just bouncing around going, business, 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 business. Is it working? Is it working? Business, business, business. And if that is reminiscent to you of Jen Shaw, business, business, business. Business, business. Right. Despite Kouri Richins Realty existing debt and insufficient revenue, the defendant continued to use hard money loans to purchase 3 additional properties in November 2021. When the defendant closed on the 3 properties on November 30th, 2021, she added $1.1 million in high interest debt to her already staggering and unserviceable debt load. By that day, she had already defaulted on 1 loan and was delinquent on several others. She continued efforts to borrow from new high-interest lenders and meet her existing obligations. And this starts getting into the causes of action here. On December 23rd, 2021, defendant contracted to purchase an unfinished mansion in Midway using $2.9 million in high-interest debt due in 6 months, even though she lacked the financial ability to service the additional debt, refinance the debt, or rehabilitate the property, or otherwise dispose of the property. Right. The defendant was scheduled to close on the property on March 4th, 2022, the day of Eric Richins' death. Right. Because if she brought in all the life insurance money, then she would be able to either rehab it or service the debts on the Midway mansion, because it meant more to her than anything else. She ultimately closed on the Midway mansion the next day. On the day of Eric Richins' death, Kouri Richins Realty owed hard money lenders at least $1.8 million, and the day after Eric's death, it owed nearly $5 million. At the time of Eric Richins' death, at least 3 insurance policies on Eric Richins' life existed with an aggregate death benefit of $1.3 million, and the defendant as the beneficiary. And wait, no, I read that weird. But the defendant was the beneficiary, $1.3 million. A 4th policy existed with a death benefit of $500,000. Defendant mistakenly believed that she was the beneficiary of that policy as well. A fifth policy existed that paid approximately $168,000 towards the balance of the mortgage. So the home was paid off. Actually, really smart insurance decision that there was a life insurance policy that cleared the mortgage on the home, and then the home went into the trust for the kids. So the kids could live there without a mortgage and just service, or the trust would just service the property taxes. It's a very good strategic life planning setup. There's a better word for that, but you know what I mean. This is good financial planning right here. So there was a life insurance policy on the primary breadwinner that covered the rest of the mortgage. Smart. At the time of death, Eric Richins' estate was worth approximately $5 million. Right. The defendant, her family, K. Richins Realty, and CNE banked with America First Credit Union. And then they go through the Navy Fed line that Kouri also had. Defendant submitted a falsified bank statement to Iron Bridge Financial, not Fake Forge, Iron Bridge, not different case, not Murdaugh. Though the defense seems to conflate it. This is Iron, not Forge, different things. Iron Bridge Financial in support of a mortgage loan application. This starts to break down, and we're gonna jump through some of these quickly. The same type of scheme that we saw in the murder trial with her like cutting and pasting her business bank information onto CNE Stonemasonry's bank information. So she would take the header and footer from hers and use the body of Eric Richins. On July 2nd, 2021, while processing the mortgage loan, an Iron Bridge representative noted to the defendant, quote, "When I ran your credit, it was lower than I expected. Looks like there are some delinquencies with regards to a few credit cards. I was just a bit surprised by that. I know you have a lot of $ money in the bank to cover expenses." It's because that's not her bank account. Hey, mortgage representative, it's because she's lying to you. Trust your gut on that one. Trust your gut. I know you have a lot of money in the bank to cover expenses. 3 days later, defendant explained, quote, "I recently learned about all of this as well. LOL. And then my husband tried to explain to me this was his doing a while ago. Ellipses. We are in the process of separation for one of many reasons, but this is one of them, to keep it short and sweet. LOL. It's been crazy to say the least, exclamation point. I'm just a girl. I'm just a girl. Pot, kettle. I'm just a girl. Ma'am, you're telling on yourself. I just learned that this was my husband's fault. LOL. We're in the process of getting separated. That was July 2nd, 2021. This continues through an ongoing pattern, as they have alleged here. We have seen some of this pattern in the murder trial. The court kept out a lot of this information at the murder trial. So the next one is a falsified bank statement to Boomerang Finance in support of a mortgage loan application. And those are, again, the body of CNE's statement. Defendant submitted 3 falsified bank statements to Excel Financial Services in support of a mortgage application. Continuing on, defendant issued a series of bad checks and laundered money, and then they go through literally the check kiting where she is using the TikTok infinite money glitch to try to move money around before it could catch up, to try to literally shell game all of this. Because what's a little check fraud when you're already into the rest of it and trying to plan a, the homicide, it seems. let's see. So they're going through all the different checks that went one place and went the other place, and then she was overdrawing her accounts. Defendant fraudulently extracted $45,000 from her best friend. When this was filed, this was the first time we actually learned the full picture of like, bitch stole her best friend's house. Emily, we said no name calling. I mean, colloquially, girl literally stole Kim's house. Sorry, Chelsea Barney's house. And we heard a lot more about this in the trial. But this is, hey, bestie, I've got a great deal for you. Give me the $45,000. I'm going to put it down on your mortgage. The mortgage is all yours. The house is all yours. And then Kouri never completed the documents to transfer title. And then the day Kouri was arrested, she had just put her best friend's house up as collateral on yet another loan to keep the shell game going, which ended with Chelsea Barney being evicted. Right. Defendant submitted falsified insurance application on Eric Richins' life. Defendant attempted to murder Eric Richins for pecuniary gain. This is the breakdown of the Valentine's Day incident. What's interesting here is we learn a lot more about the witness, Hayden Jeffs, and that conversation that we didn't see in the murder trial, because in the meantime, he was in a motorcycle collision and passed. So we saw his partner testify, but we didn't get this testimony at trial. And this is what Hayden Jeffs would have testified to had he not passed due to a collision. Annie in the chat said, I take it Chelsea never got her money back. No. And it's not even that Chelsea didn't get her money back. It's that the $45,000 was supposed to go into the mortgage and it didn't. So the down payment didn't go to the mortgage. And then Chelsea was also paying on the mortgage every month. And then the home got foreclosed. So she got no value out of the home for the years that she paid the mortgage, and she didn't get the money she put into the home back. Yeah. Right. Let's take a look at what this testimony would have been. The defendant occasionally employed Hayden Jeffs to assist her with renovating houses. On January 20th, 2022, the defendant, Richins, text messaged Mr. Jeffs, quote, I did want to chat with you about something super random, ! Not now, at kids stuff. I'll call you tomorrow if that works. Meet me after by the benches, ma'am. Diabolical. I need to talk to you. I mean, not right now. I'm at kids stuff, but I'll call you tomorrow. On January 21st, 2022 at 7:24 p.m., the defendant text messaged Mr. Jeffs, hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd, 2022 at 11:06 a.m., the defendant texted Mr. Jeffs, got a sec. Mr. Jeffs told law enforcement that he spoke with the defendant on January 22nd, 2022, and the defendant asked him for fentanyl. The defendant told Mr. Jeffs that she wanted the fentanyl for a client who had back pain. Mr. Jeffs told the defendant that he would not get her fentanyl, and then that the defendant hung up on Mr. Jeffs. Super random. Any fent? For those of you asking, this is not the paramour. This is not the side piece. On January 22nd, 2022 at 5:35 p.m., after the phone call in which Mr. Jeffs declined to get fentanyl for the defendant text messaged Mr. Jeffs, quote, have another one for you. Call me if you got a sec. Mr. Jeffs told law enforcement that during a second phone call with the defendant on January 22nd, 2022, the defendant asked him for propofol. Mr. Jeffs told the defendant that he could not get her propofol. That was the conversation that we heard his partner testify about. His partner testified about them being out together and then hearing this phone call about the propofol. The partner did not testify about the text message conversations regarding fentanyl. And because Hayden Jeffs had passed away, he couldn't be asked about it. However, if Kouri had testified and they had these text messages, they could have asked Kouri, but didn't you text Mr. Jeffs this? The problem is the request for fentanyl was on a phone call, not on this. And it would be difficult to introduce the hearsay statement to the detectives if on the stand they confronted Kouri and Kouri said, I never said that to him, because now you have a Sixth Amendment confrontation issue because the witness is unavailable. So this becomes a situation that's difficult. So this did not come in at trial. And now we know why it didn't come in at trial, and we know what it would have been. She asked for fentanyl, then she asked for propofol. So, continuing on, the text messages from January 22nd, 2022 between the defendant and Mr. Jeffs were manually deleted from the defendant's phone. After that date, the defendant and Mr. Jeffs did not communicate ever again. The defendant and Mr. Jeffs had communicated regularly throughout the prior year. On May 31st, 2022, approximately 3 weeks after defendant's arrest for Eric Richins' murder, the defendant's mother got a text message from defendant, quote, Mr. Jeffs running his mouth. My phone is hearsay, said, but can't they use the statement he gave? No, not at trial. Because there's no confrontation. The defense never had a chance to cross-examine him. It was an out-of-court statement given to law enforcement. There are limited uses, but they are incredibly limited. And most of those wouldn't trigger unless Kouri testified. And even then, it could be incredibly difficult. Kouri texted her mother, Mr. Jeffs running his mouth. When this goes to trial on the financial crimes, and we're going to go to court for the financial crimes when we finish up with this. I had actually forgotten this was in here. I'm glad we reviewed it today. This won't come in. And it won't need to, because when we get through the financial crimes case, Kouri's already been convicted of the attempted murder for pecuniary gain, and that'll just happen there. Texted her mom, Mr. Jeffs running his mouth. Yeah, I bet he told law enforcement when you got arrested for Eric Richins' murder. I bet he was just like, shit. She was asking me for fentanyl. Because by then it was already known that Eric Richins died of a fentanyl overdose. Yeah, I bet he had a few things to say. Kouri, why wouldn't he? You tried to pull him into this whole thing. And then they move on to talking about Carmen Lauber. And we are going to get back to Carmen Lauber today because it's one of the sidebars we're going to cover. But then they talk about the contact with Carmen Lauber. Then they talk about the contact with Robert Crozier. Again, this isn't going to come up when this goes to trial because it's all already been proven. Let's see. This is about the hand-to-hand transactions. The breakfast sandwich, this all goes to the attempted murder, but there's more information in here that we did not see at trial because this is a charging document with the probable cause. This is more information that didn't come in at trial from Valentine's Day. I forgot this was in here too. At 9:41 a.m., the defendant text messaged her paramour, headed that way, ellipses. At 9:49 a.m., the defendant text messaged him a screenshot of a navigation application on her cell phone showing her current location on SR 32 in Camas and her projected arrival at an unknown destination at 10:49. At 11:09 a.m., Eric Richins placed a 2-minute phone call to the defendant. At 11:27 a.m., Eric Richins text messaged a photograph to the defendant. That photograph has been deleted from both the defendant's and Eric Richins' phone. I have thoughts. At 11:33 a.m., Eric Richins text messaged the defendant, "I'm going to go lay down for a bit. If I don't start getting better, I'm going to head to the hospital." I wonder if that photo was regarding him breaking out in hives. Because from all the information we have seen, it seemed that he had a hive-like reaction to that breakfast sandwich, which is not an uncommon reaction, as we heard with fentanyl. So I wonder if that is what the photo was of. So he then texts her, "I'm going to lay down. If I don't start getting better, I'm going to head to the hospital." That was not admitted at trial. It's not going to come in during the financial crimes case either. 1 minute later, the defendant responded, "Geez, it's that bad? Need me to come home? Go to take a nap and call me when you're up." And within the text messages, they've noticed when the misspellings are there. And I think the prosecution, every time there's a misspelling, is like, "She spelled the wrong your. It's not me. It's not me. Why don't you lay down and sleep?" This is kind of where that all started, with me saying, "Why don't you? Oh, it's that bad? Okay, go take a nap. Why don't you lay down and sleep? You let me know." 5 minutes later at 11:39 a.m., activity recorded on Eric Richins' phone and associated devices ceased. Activity did not resume until nearly 2 hours later at 1:32 p.m. The judge kept a lot of this out during pretrial motions. It's not going to come up during the financial crimes case because she's been convicted of attempted murder and murder for pecuniary gain. So the additional details will also be kind of stripped out of this. But this is when we talk about the prosecution potentially having a devastating rebuttal case in that trial, these are the things that the defense knows are sitting out there. At 1:59 p.m., Eric Richins called Kouri Wright, a close friend. Mr. Wright could hear fear in Eric Richins' voice and tell that Eric Richins was scared. There's more to that. I know that he gave a very thorough interview with law enforcement, if not more than one. We did not learn about all of that because what Eric Richins told Kouri Wright is hearsay. How Eric Richins sounded, and Kouri said he had not heard Eric sound that upset other than when his mother died. Look, when your friend and business partner, when somebody you interact with every day and have since you were growing up, is shaken, you know. At 2:11 p.m., Eric's called Josh Kays, another close friend. Kays was struck by the tone of Eric Richins' voice and said that he seemed different, down, and somber. Right. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions to include hives. Eric Richins did not have any food allergies. The defendant and Carmen Lauber exchanged 30 text messages on Valentine's Day. On June 18th, 2022, 3.5 months after Eric Richins' death, defendant text messaged her best friend about the incident. Now I want to know which best friend this is. I think this is Chelsea Barney, to the best of my memory. It might have been Allie Staking. I'm not sure which one. The defendant wrote, "It was Valentine's Day, and Eric and I were both working from home that day." This did come in at trial. "And I ordered lunch for him from the diner. He never broke out in hives or used an EpiPen. I was fucking with him. He said the sandwich hurt his stomach, so he was going to take a nap. No hives, no EpiPen." And this is why I think that the photo was of him breaking out in hives. Especially if he had never broken out in hives before. Like, I would imagine it, when you break out in hives for the first time, you're showing someone else going, "What the fuck is this? What is this? What do you think this is?" It's not pleasant. On August 22nd, nearly 4 months after defendant was arrested for the murder of Eric Richins, the defendant discussed this incident in 2 phone calls. In a phone call with her mother, defendant confirmed that she was the person who picked up sandwiches from the diner. This came in trial. She said, "We ate in the office. In a phone call with her brother, the defendant discussed buying lunch at the diner that day. Then they go through some of the underlying things with regard to the murder. Her statements to EMS, we saw those in pretrial motions. We saw those in trial motions. They bring in what the pathologist said from the medical examiner's office. And let's see. This is all of the defendant's statements to law enforcement. We went through that pretty thoroughly in the murder case. I'm just trying to see if there's anything else that we learned in this that we haven't covered. They bring in all of the Google searches. That's where we're at now. Can you delete everything off an old iPhone without actually having it? Women, Utah prison. Can cops uncover deleted messages iPhone? Can cops force you to do a lie detector test? If someone is poisoned, what does it go down on the death certificate as? How long? It says how, not hows. How long does life insurance companies take to pay? What is a lethal dose of fentanyl? In addition to luxury prisons for rich people or for the rich. Defendant fraudulently claimed insurance benefits on Eric's life. Fraudulent because she lied about a number of things. Pattern of unlawful conduct. The pattern of unlawful conduct is predicated upon the offenses charged in counts 1 through 25. So that is an overview of the financial crimes case. It's a lot more instances of the same behavior that we saw in the trial. It's a lot more of, this is my bank account, but it's not her bank account. Here's a check, and I'm going to withdraw the money before the check clears. And then when the check clears, we're going to be in the negative, like hundreds of thousands of dollars. Right. So now I think it is a good time for us to go to court in the fraud case, because this is the case we are going to be focused on going forward. Well, we're going to be in appellate land for quite a while on the other case. And we're going to see how the prosecution goes forward on the financial crimes case. We are very early days. The financial crimes case hasn't really had a proper hearing yet, a proper setting. When the financial crimes case was filed, there were a number of hearings where Judge M was asking her defense attorneys on the murder case if they would handle the financial crimes case and if they wanted to trail it behind the murder case. By trailing it behind the murder case, it means nothing really happens in the financial crimes case until after the murder case is done. And there was some pushback with Lewis and Nestor saying, because they are contracted with the county, similar to what we see in Idaho with Ann Taylor, but they are contracted with the county for defense work. They are not from the public defender's office. Each time they take work from the county, it needs to be contracted. They did not have a contract for the financial crimes case. They said that the financial crimes case was not really their wheelhouse, which I agree with a lot. But the court asked if they would stand in essentially to represent Kouri as that case got continued behind the murder case. After Kouri was convicted, they filed a motion to withdraw, saying, this is not our case. We do not have a contract. Judge M allowed them to withdraw from the case, and a new lawyer was appointed. So this is the first hearing where we are seeing the new lawyer. This is the first hearing where the financial case is really standing on its own. And this is the first time we're seeing what kind of pacing we're going to get with the financial case. What does it look like from here? Well, we're going to go look at the hearing today. But remember, in the murder case, it took more than a year to get to preliminary hearing. If this case starts getting tracked towards trial, I imagine that one of the things we're going to see is some more complaints from the defense that Kouri Richins can't go to trial in Summit County after how high profile the murder case was. Because people are going to walk in and look at her sitting there and be like, Miss Ma'am, we saw the murder trial. You did what you did, girl. Like, it is what it is. So I think we will see some complaints from the defense that this case can't go to trial in the jurisdiction. However, Kouri has also been sentenced to life in prison, period. So is this the type of case that may be able to resolve short of trial? Maybe. But I imagine they're going to want some restitution, especially to the individual that was harmed, in this case, Chelsea Barney. I understand that the empathy for mortgage companies and banking institutions is different. I understand that. But there are a lot of companies that deserve restitution. And then there are some that are maybe less deserving. Some of those lenders that just continued lending, even though the behavior was getting wild from Kouri, you had an opportunity to pull the plug and you didn't. It's kind of how I feel about some of the people that kept lending to Murdaugh and Girardi. You're chasing good money. You're chasing bad money with good. And that's kind of on you. Like, you're making a choice. Chelsea Barney? No. I want to see Chelsea. What I want from the financial crimes case is to see Chelsea Barney get some level of restitution. The same way I want to see restitution made that goes back into the trust of all the life insurance money that should have gone to Eric Richins' children. Those are the parties I want to see made whole. Do I think it's okay to steal from companies? No. Do I think companies were in a better position to assess the risk than Chelsea Barney was? Yes. Absolutely. Also, a lot of those companies have insurance, and some of the hard money lenders saw a disturbing pattern of behavior from Kouri and could have said no. So am I as worried about them getting restitution? No. Do I want to see Chelsea Barney and the trust be restored fully first? Yes. Would I be displeased if there were millions and millions and millions in restitution orders, so that if Kouri ever had any money come her direction ever and ever, it would never go to her? Yeah. Yeah, I'd be fine with that. Lara said, will we see the same financial expert in the financials trial if this goes to trial? Yes. But I also, when I look at this, I look at who was in the position to make better decisions. And the mortgage companies were in a position to make better decisions, but they didn't even see the same pattern of behavior as the hard money lenders. The hard money lenders were in a much better position to say no. And then the life insurance companies were getting fraudulent signatures or a fraudulent power of attorney. And so I think that the life insurance companies were doing the best that they could. So we'll see. With that, we're going to go to court. A huge thank you, though. Tina, thank you for the 50 gifted memberships. That's incredibly generous. Welcome, new law nerds. Welcome. Enjoy No Slow Mode. And there is an entire backlog of members-only videos that are now available to you. So welcome. All right. For those of you that missed our earlier flight, we flew to Utah before this longer road so far. We're going to fly to Utah again for funsies, and then we're going to go to court. Sound good? I don't think we're going to complain about flying to Utah twice. Literally, we're living up to Utah. Give me two. Emily? Yeah, Point Break. It's Point Break. Just in case there were any questions. It's Point Break. So Utah. Give me two. We're going to go to court. Let me make sure the video's pulled up, and we're going to fly. Hold on. We're not ready for your glorious voice yet, Judge M. Just give us a second. Let's go. All right, we are going to court. This is from earlier this morning. We are going to get to see Judge M again. I've missed him too. Don't worry. Wrong screen. It's like, ta-da, Judge M. No, that's an information, Emily. That's not Judge M. We've improperly gone to the wrong screen. Let's try that one more time. Try it one more time. All right, law nerds. Let's try it again. Let's go to court. All right. Kouri is appearing via WebEx from prison. Judge M is appearing via WebEx. Kouri's new lawyer is in court. This is a status hearing. It is the first status hearing on this case. Also, I don't understand where the beard, where did the beard go? Why no beard? Why is that ever a choice? I love the beard. I know. Chad, I told you. It's summer. It's fair that it's summer. I said we were going to be disappointed twice today. But we still get Judge M. But I understand that a lot of you are just like, we expect bearded Judge M. Aren't we picky? Yes, we are. Let's go.
Utah versus Kouri Richins. Ms. Fowler in the courtroom on behalf of Ms. Richins, who's present by WebEx. Ms. Shervinack on behalf of the state.
So we've seen Ms. Shervinack in trial. This is Ms. Fowler, the new defense attorney standing at the podium. The video is difficult. It does look to me that the Richins family is present here in the courtroom, both Katie and Amy Richins and their husbands. At least if I had to guess of what was going on, because that camera is terrible, I would absolutely guess that. Y'all are saying, and no Bloodworth. I believe Attorney Bloodworth is probably on vacation, because when they were talking about scheduling when responses were due, it was one of the things that Bloodworth mentioned repeatedly, that the people had vacation. So that would be my guess. But Kouri is, all of you who are disappointed they don't make her wear lime green forever, I know. But a prison garb is different than local custody.
Utah versus Kouri Richins. Ms. Fowler in the courtroom on behalf of Ms. Richins, who's present by WebEx. Ms. Shervinack on behalf of the state. We're here for a scheduling conference. What's contemplated?
Well, Your Honor, I have had a brief conversation with Ms. Olson. There is needless to say, a lot of discovery that I have not even begun to get nor review. So before we do anything, I need to have the time to do that. I am actually asking for probably 45 to 60 days to come back.
Okay. If we say September 20th.
It seems to me that the WebEx from the prison keeps freezing. So Kouri's not moving much, but I think that it keeps freezing a bit. So the new defense attorney, who is new to the case, does not yet have all the discovery. That's not uncommon. I don't even know if the defense team, Nestor Lewis, had the discovery. I would imagine if I'm Nestor and Lewis, and this isn't shade to them, Emily, really? No, that's why I'm saying this is not shade to them. If I was Nestor, Lewis, and Ramos, and I was just standing in on this case to continue it until the murder trial was done, I would say, don't even give me discovery. Truly, don't give me discovery. I don't want it to get lost. I don't want to be responsible for turning it over to her next attorney. This isn't a case we're reviewing. We're not even going to look at it. Don't give it to me. So this is the new defense attorney.
25 or October 9.
October 9th works better for me, Your Honor.
Ms. Shervinack, any objection?
No, Your Honor.
Okay, October 9, 10 a.m. by WebEx.
Yes, please. And that was the other thing. If we could just have maybe a standing order that Ms. Richins be allowed to appear via WebEx from the prison, unless there's something substantive, obviously, then we'd be able to work it out. But it's much easier for her than to be transported up here for us to get a new date or things like that.
I understand. Okay. Ms. Richins, October 9, 10 a.m. by WebEx. Please stay in touch with Ms. Fowler. I wish you the best.
Thank you, Judge.
Thank you.
I'll be back.
Take care.
Kouri, what were you saying at the end of this hearing? You didn't even say thank you. What were you saying at the end of this? What were you saying at the end of this hearing? Not even a thank you. J8 in the chat said, who's paying for this lawyer? The taxpayers of Summit County. But yeah, October 9th. I'm sure she's not thrilled. Kouri, you got nowhere else to be. Also, I wonder if Kouri has had a conversation with her lawyers about the, or probably family members, about the motion for new trial being heard by Judge M.
Get a new date or things like that.
I understand. Okay. Ms. Richins, October 9, 10 a.m. by WebEx. Please stay in touch with Ms. Fowler. I wish you the best.
Says nothing to the judge. I wonder if she just looks at the person in custody and is like, we're done. It's over, or something like that.
Thank you, Judge.
Thank you.
I'll be back.
Take care.
Yeah, she really just might be looking at the guard, and because there would be somebody in that room with her saying, and that's it, we're done. Literally two minutes.
WebEx, please stay in touch with Ms. Fowler. I wish you the best.
Thank you, Judge.
Thank you.
I'll be back.
Take care.
Yeah, she doesn't respond to the court at all. No thank you, no nod, no nothing. So, Angela, CEG Wednesday's live stream. Judge M never recused himself. Judge M sent it to another judge to review, and that judge said, nope. Hold on, wait, we need the Yannetti nope. Hold on.
Nope.
Yeah, the other judge said,
Nope.
and now Judge M is in charge, is still in charge of this case. So that's the end of the hearing today. That's it.
Let me just make clear for the numerous observers that are on. Thank you.
I'll be back.
Take
in a
care.
moment.
Let me just make clear for the numerous observers that are on my WebEx feed, there will be no further Richins proceedings today. You are welcome to log off. I have a lot of other cases to handle. Thank you.
I don't know who was chuckling in court, but he's like, I have a lot to handle. Thanks, everybody. Bye-bye. Bye-bye. Bye-bye.
Yes, ma'am.
Bye-bye.
Let me take.
All right. So that's it. That's all. That's the entirety of what happened in court today on the Kouri Richins case because the restitution hearing had gotten put over. So we are put over for another date. It's interesting to see that Kouri didn't say thank you, didn't nod, didn't acknowledge the judge at all. Am I surprised by that? Not necessarily. Do a lot of court hearings go that way? Yes, they do, which is why we're going to look at sidebars today. But I will say that I wanted to log in and make sure that we had media access to the WebEx today and to the hearing. The hearing started a little later and Judge M was running drug court. And so I had the opportunity to watch Judge M in court, kind of case after case before this case was called, which I haven't really had the opportunity to do. I have not yet, though I feel like I must at some point make my way to Park City and hang out in a courtroom and just watch Judge M run court all day. But I really appreciated the way he was running court. He was running mostly drug court when I saw it before the Kouri Richins hearing. And it was great. It was fantastic. I know all of you are like, we want to watch. Judge M has a very strict media order that media is not to transmit this case until the Kouri Richins case is called. And once the case is done, there isn't to be any transmission, which is why I'm sharing with you my observations, because if you live in the area and want to see how Judge M runs his court, these courts are open day in and day out. You can really just go sit and watch court in Judge M's courtroom. So I was watching him run drug court, and a few things stood out to me. One, he asked everyone that was appearing before them, and again, all drug court cases, he was asking every single one, what are you looking forward to? And having a conversation with them about what they're looking forward to, not just in the immediate future and the near future. He asked all of them about their jobs, asked them about what was going well for them, asked them about what their experience was with drug court. And when there were people who he needed to give a little pushback on, he gave a little bit of pushback, but in a way that is different than I have seen some other judges. There was a gentleman who was in custody for violating terms of probation, and Judge M looked at him and was like, you are making bad decisions right now. And you are in this program so that you can be making better decisions. And everyone wants you to succeed. Hold on. Something triggered one of my devices, and I don't know what. But he said, everyone wants you to succeed, and you are making choices that are going to make it impossible for you to succeed. And I'm summarizing it. He said, when you are sober, you are a great employee, a great son, a great member of the community. And none of that is the same when you are not sober. You have got to stay sober, and you've got to make different choices. Your employer wants you back. Your family is here for you. But you have to make those choices. And it was very much I am holding you accountable, and I am expecting that you will make better choices for yourself because you deserve to make those better choices for yourself. And asked every single person who came before his court how many days of sobriety they had. And clapped and celebrated with each and every one of them. And so did others in the courtroom. Somebody got donuts today. I'm not quite sure what the donuts were for, but somebody got donuts today. And then for the people who were doing really well in their drug court program, I don't know if he has a bowl or a basket or something, but he has like reflections in his courtroom and had them from the podium, because he had everybody standing. Everybody who came before him in court today in drug court came and stood at the podium. They didn't sit at defendant's table. They came and stood at the podium and talked to him on a more equal level instead of sitting at the defendant's table. So he had them come up to the podium, and then he had them come up and pull up like a reflective question. And one of the questions that was pulled was, what advice would you give to somebody in drug court? And the individual before him shared their answer, and they had a conversation about it. Somebody else pulled what are you most proud of in the time you've been in drug court, and shared with him some of their really proud moments. And it was really clear, not only that he was getting to know those who were before him in court quite a lot, but was genuinely rooting for him. And I imagine that if you were on drug court in front of Judge M, you would want to be able to complete drug court and come back and say, I've done it. And that he would genuinely celebrate with you. It was really nice to see how he's running his court day to day, which again makes me all the more outraged when we see the audacity that the defense is trying to pull, because there is a tremendous amount of genuine empathy. And then when defendants were struggling a little bit, there was pushback and accountability. But he has an ability to come at that from a place of, you deserve better for you, and I am here to hold you accountable for deserving better for you. One of the defendants, who seemed to be struggling quite a bit with driving under the influence, was asking about their license. And he was like, I think what we're going to need to do is explore bike options, because a vehicle's just not in the near future. So I don't want you waiting to do things until there's a vehicle. You're not going to be driving. So maybe it's time to look at bicycles. That seems like an option. He's like, we can look at other solutions, but it's not going to be that. But not just what do you mean you're asking me about your license? Let's, because a lot of judges would be like, it is way too soon for you to be even asking me about your license until you get further on down the road. There are two ways to handle everything. And instead it was, let's not wait for that. That's going to be a little ways off. Let's plan for now. It's just a different way of saying exactly the same thing, but I think it goes so much further with individuals. So it was really nice to get to see a little bit of Judge M just running court in the day-to-day course, where when he's saying at the end of the court hearing to Kouri Richins, I wish you the best, I truly think that Judge M is looking at humans being like, you might have ended up in front of me due to a lot of wild choices, but genuinely handle your stuff and take care of yourself. At the end of the drug court today, he told everyone to take care of each other. And I was like, me too, Your Honor. Me too. So it was really lovely to get to spend a little bit of time in the day-to-day running of Judge M's court. And I'm glad I got to see it. So I wanted to share a little bit of that with y'all, because it changes a little bit of how we've gotten to see him just interact in this case, but also just solidifies that there are so many different types of bench officers. And maybe one day he will let us just stream a day in court. But I also realized not every defendant who's in drug court wants all their business put on blast. And he doesn't choose to stream his court day to day. But it is nice to see the humanity that he brings to the bench, because there are times where you can see the day-to-day of court just becoming more of a grind. And that's not what I at least saw today in waiting for this hearing and seeing Judge M's running of his court. It was really nice to see. And I think that when we have so many moments in court where we're just like, well, that's a bit rough, it only makes sense to balance it with the moments that are truly lovely. I don't think I've ever seen a judge ask for reflections. And there was a moment with a gentleman that was in custody that was clearly struggling with his probation. And Judge M's like, look, just breathe with me for a minute. Like, just take a deep breath. We're going to figure it out, but you've got to figure it out. Like, we're here to help you figure it out, but you've got to figure it out. You, at the end of the day, you are the one that has to make the choices. And you are the only one that can make the choices. We can do everything that we can do, but you have to make the choices. And was like, take a deep breath. Like, everything short of saying, pause, take a breath. I can only imagine that he was looking at the person in front of him and could see the stress and was like, take a breath. You can do this, but you have to make better choices. And you should want to make better choices for yourself. And it was lovely to see. Really, really lovely to see. So, yes, day to day, Judge M continues to prove that A, he is an empathetic and compassionate human being, but also he runs his court consistently with patience and with a level of listening that can actually help people change without screaming, we were all rooting for you. Because there were definitely times in court with defendants who are on probation or what have you, where I was also rooting for them as the prosecutor. I'm like, I see the circumstances in your life that have led to all these choices. I genuinely want to see you make better choices because you deserve to live a life that's better than this. And you can have that, but you have to be able to make some better choices. And there's a lot of times where you're just hoping that people can overcome the things that throw them off track. There are some cases where that is not the case, but when you were looking at people struggling, I think the balance of we're rooting for you and when things go wrong, I'm not going to just pretend it didn't. We're going to have accountability, but the accountability is still coming from a place of, I'm going to want better for you, even if you don't yet. Absolutely loved it. And then at the end of that, it seemed that there was an individual that had logged into WebEx who was getting ready to start the drug court program. And Judge M wanted them to watch the hearings for the day so that they knew what they were getting into. I've never seen a judge do that, ever. Hey, log in and watch what we're doing in drug court. I've never seen a judge give someone I want you to do this program. I think it's great. Come watch what it's like. Absolutely incredible. Absolutely incredible. Just 10 out of 10. Emily, you're just fawning over Judge M. Look, I have been in front of some great judges. I have been in front of some judges whom I check for their obituaries regularly. I have had the gambit. And when people feel like you are listening to them and rooting for them, it might give them the encouragement they need to make a different choice for themselves. And I think that that's incredibly important. And it gets lost sometimes. But there are many judges who are fantastic. And sometimes it's all too easy for me to get frustrated with the ones who aren't. I'm really glad that we got this peek into Judge M's court today and I got to share it with y'all. Because truly, it was great to see. And I wonder what the experience is like for those who are going through his court as well. Because I imagine many feel encouraged. And even if they don't feel encouraged in the moment, in hindsight, they do. Absolutely love it. Absolutely love it. Absolutely love it. So, do we want to get to sidebar? Do we want to get to sidebars? Pen pal, yeah. I've told this story on maybe one or two members onlys. There are a couple judges that I don't know, man. The devil might just be like, how many levels we got? Because I don't know if I want to contend with you. There are some tough judges. Most of the judges I've worked with are great. And you want to see a judge that's actually rooting for people. But also, it gives me a lot of context for what we're about to talk about. Because also, This is not the judge. Like, this is not the judge. We have watched, y'all that haven't worked in court, we have watched a lot of judges together. This is not the one, fam. Like, this is not the one. So this motion for new trial is so fucking wild to me with context. And the defense should have this context. They are experienced trial attorneys. I can't fathom an attorney finishing doing trial before Judge M, and their argument with Judge M is, he was mean to me. It's mind-boggling. Absolutely mind-boggling. And we're going to boggle a little bit more today. Why? Because it's Friday. Because it's Friday. And we haven't figured out what made Judge M tell Nestor to slow her roll. And that is just a miss that we haven't had a chance to do that yet. And so before Emily goes galloping off to literally the busiest week of my year, we're going to find out. We're going to find out. So, Miguelina, will you let the app know that we are going to delve into some sidebars in case anybody was just like, I don't know, man. I saw online that this hearing was like 3 minutes long. It's not for me. That's fair. We'll be back on the fraud case in October and see what happens. Because remember, that case hasn't gone to prelim yet. Lyft said, and I just got paid. Yep. It's Friday. Let us go. We have to do all the things. We're taking a look for context at the defense's ill-conceived motion for new trial. Have any of you not heard me cover this motion yet? Just put a 1 in the chat. Have any of you not heard this motion yet? For those of you that haven't had a chance, there's no judgment. I just want to make sure I give the appropriate amount of context because I know that those who have covered it are ready for the salt anyway, like mining salt. So it's fair. There are some of you that haven't seen it yet. Fair enough. Let's do a quick road so far. That's fair. Road so far on the defense's motion for new trial. Emily's feelings on this motion are bold strategy. Let's see how that goes. We have covered a lot of motions for new trial. They are expected at the end of a trial that resolves in a guilty verdict. There are very few trials where we do not see a motion for new trial. I think one of the only trials we've seen a conviction without a motion for new trial is probably Karen Reed trial 2, where she was convicted of the just like basic DUI. And they were like, we'll do the year probation. It's fine. Let us go. Goodbye. I think that's the only time we have not seen a motion for new trial because that trial was basically an acquittal on all fronts except for a DUI. And they're like, we'll take it. We're fine. We're just probation. Let's go. Bye-bye. So a motion for new trial is expected. What is unexpected to me is that the majority of this motion, and by majority, I mean the vast majority of this motion, is complaining that Judge M was biased and unfair. And there are different moments during the trial that the defense complains of. We're going to look at a few of those because a number of things they have discussed happened at Sidebar. So we did not hear those when we were watching the trial. So we pulled up some of the motions on video the last time we went through all of this, and we looked at some of those moments in court, but we didn't know what happened at the sidebar before it or after it. So we didn't have the full context. The defense also argued that there were 2 rulings, I believe they are rulings, that should, no, not 2 rulings. They also argued that the judge let in too much of the financial crimes information, and then they misstated the premise of the Murdaugh case being overturned. And I lost my mind. Lost my mind on that. The third premise, let's see, what was the third premise? I don't even remember, because the audacity of just being like, the judge was biased against us and unfair, so we need a new trial, was so crazy. Their third point was cumulative error. Too much financial crimes plus bias means it's just all bad. Give us a new trial. Okay. So we're going to take a look kind of point by point and then pull up the sidebars as we have time to do. I will give you an overview of their motion because it's bold. After this motion was filed, the court said, it seems like you are making a motion to disqualify the judge or have the judge recused. The judge said, I think another judge needs to review this. And that judge issued their ruling on Wednesday while we were streaming. So we covered it as a new filing at the end, towards the end of stream on Wednesday. And the judge said, yeah, no. This judge is not biased. This doesn't even raise the level. And you procedurally did all of this wrong anyway, which I imagine we will see come up later. I am sure. I am sure when Kouri Richins eventually complains about IAC, that will be the thing, that they didn't even make a motion properly to disqualify the judge. I would really hate to think that we are teetering into a time where defense attorneys may do things procedurally improperly to gamify the system. I do not think that's what's happening. If there is evidence that that's what's happening, it is ethically improper and there should be repercussions for that. I don't know if this defense team is quite that strategic or if they're just scattered. But if that were ever the case, because it's so many misses, they made this massive motion and said bias, 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 but then they never made a proper motion to disqualify the judge, and it's too late for them to do it. So it will come up when there is post-conviction relief requested for Kouri. I don't think it will go anywhere, but it will come up. So let's get into a little bit of an overview of this motion, and then we're going to use this motion as a guide to where we need to go dive into some of the sidebars. All right. Ms. Richins' convictions should be vacated and a new trial granted for the following reason. 1, the court's clear demonstration of bias in favor of the state displayed before the jury deprived Ms. Richins of a fair trial. 2, the state's repeated reliance on other crimes, wrongs, or bad acts, and the admission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several categories went far beyond the court's pretrial rulings and violated rules of evidence 401, 402, 403, and 404B, and resulted in substantial undue prejudice, denying Ms. Richins a fair trial. And 3, cumulative error, which is like all of it. The premise of their argument: the court's repeated assistance to the prosecution and disparate treatment of defense counsel before the jury denied Ms. Richins her right to a fair trial. Dude, the court was stacking XP on how many assists the defense got in this case. Throughout the trial, they say, the court repeatedly interrupted defense counsel, corrected counsel in ways that suggested to the jury that counsel was mishandling witnesses, assisted the prosecution with its objections, and curtailed the defense's objections. By curtailed, do you mean the court said, your objection is noted? Your continued objection is noted? Because the defense was objecting in a way that was, I think, strategic to throw off the pattern of questioning and answering. Right. The misconduct of the court. This misconduct created an appearance of bias against Ms. Richins and in favor of the prosecution, depriving Ms. Richins of a fair trial. In this matter, I'm skipping forward a bit. We will link the video where we went through this the first time all together, because even though we've seen this like 17 times, I'm still just like, what the fuck? All of you who got the app notification and are like, this is so helpful, wonderful, welcome. We actually are working on a new way to make them even faster. And I'm super excited because I think we'll get to roll it out after Travis gets moved into college. And I cannot wait to share it with y'all because it'll make it even faster. And I'm super excited about it. As a side note. In this matter, they say the court engaged in repeated conduct that denigrated defense counsel both in and out of the presence of the jury. The court was often impatient, critical, and hostile toward the defense and only the defense. Footnote 1. See trial transcript, day 12, page 146, line 14 through page 148, line 16. At the bench, the court angrily criticizes Ms. Nestor's objection, telling her to, quote, slow her roll and reminding her that to, quote, that's their sentence, that's not me, I'm not reading badly at the moment, and reminding her to, quote, read the ruling that I issued yesterday and try to avoid plain error to help your client. Further, the court tells Ms. Nestor that she needs to wrap it up because, quote, I have parent-teacher conference to go to. I wonder if that's misquoted. And my son barely recognizes me. And this is the footnote that made me lose my mind. Because one, it is such a low blow. It is clear that you knew what the court meant in saying I've spent so much time in this trial that like my family doesn't recognize me. It's not a colloquial phrase that is unfamiliar before the law. Also, do not shame other parents in footnotes when they are trying to remind you about why they need to wrap up court early or just wrap up court on time. Awful. Absolutely awful. The only point of putting this in here is to poke at the court. There is no other reason to put this in here. The court tells Ms. Nestor that she needs to wrap it up. They could have continued with depriving her of the adequate time to argue her motion and not allowing her to continue the next day or whatever. It's dirty. And it's uncalled for. So what I think we need to do is just go to trial day 12, page 146, and see where we're at. Because this seems like a whole big bag of bullshit to me, but I would like to know. So, to day 12 we go. Because, well, we must. Let me try to get to page 146 quickly. Because it's a transcript and it's not timestamped. I think we will jump in a little bit before page 146 so we can figure out what the context is for what's going on. Because there's probably more. Let's see. I'm trying to figure out which witness is on the stand while this is happening on day 12 of trial. Let's see. I'm going to look. You know what? I'm just going to pull this up and we're going to look together. Try to figure out which witness is on the stand when this all happens. I don't know if this is the, let's see, Ms. Nestor, the court, Ms. Nestor. Is there a, let's see. It looks like they're at a pretty substantial conversation just with the court. This starts on page 122. A bench conference was held outside the hearing of the jury as follows. So let's back up. They are talking to Mr. Kostradimos, it seems. Let me back up a little bit more. No, this is a hearing. They're still not questioning a witness. It's just like the court and counsel. But it looks like technology. Let's see. Bloodworth, court, witness. All right. I'm going to back up and see which witness we're on. They're talking about Carmen's house. Let's see which witness gets called to the court. And then we are going back to page 122. Because I'm not quite sure which witness it is. You know what? There's a faster way to do this. Hold on. We're just going to go to the beginning of the page. Sorry, chat. I didn't want to scroll too fast, and then we'll jump back to page 122 when we get to that bench conference. We'll just look at the guide at the beginning. I thought it would be easier. It was not. I appreciate that the court reporter just put question, answer, and not speakers, but it makes it a little bit difficult. This is the afternoon of day 12. Let's see. Carmen Lauber and then Jeff O'Driscoll. So all of you who said O'Driscoll, correct. Carmen Lauber and then Jeff O'Driscoll. So this would have been during, there we go. This would have been during O'Driscoll's testimony. Perfect. Let's go down to page 122 now. Let's see. Again, this is in the afternoon. Oh, this is going to be difficult. Let's just get us to page 122. Nope, it's going to go every single page. Sorry, we're scrolling. Thanks, chat. Because I'm real curious about what happened. We know that there was a lot of sidebar while O'Driscoll was on the stand, and then we know that there was argument with the jury removed from the courtroom. So I think, and this is based on my memory, actually, Megalina, will you pop day 12 into our notes in case we need to just roll the tape? Thank you. We're going to go to this first, but the defense was trying to get into things with Detective O'Driscoll that they couldn't get into, and they were trying to sidestep things with O'Driscoll that were not going well. Because I remember losing my mind during parts of this where the defense was trying to get into stuff that the court had already ruled out. And they were trying to make it seem like maybe Eric had sent those memes. And then it wasn't until the next day that it became a little more apparent that they were trying to insinuate that like the memes were coming from Eric's phone. And I think they were trying to confuse O'Driscoll on that so that the way it was perceived by the jury would be like, wait, was Eric sending those memes? I think this was done with O'Driscoll because I think they thought they could trip up O'Driscoll because it wasn't going to happen. It wasn't going to happen with Gabler because they were trying to insinuate that there was an affair going on between Eric and Bryce with Gabler, and Gabler's like, that's 100% a no. All right. So let's get to where the bench conference begins. And they cited the court to page 148. We are starting at page 122. A bench conference was held outside the hearing of the jury as follows. Miss Nestor, yes. So it sounds like the court. All right, let's back up and see what led up to it real quick. We're backing up a little bit. Let's see. Miss Nestor, do you recognize this exhibit? Answer, yes, it's State's Exhibit 313D. Question, this is Nestor on cross. And is it fair to say that this exhibit is a visual clip of the locations where Eric was on February 14th of 2022 based on geolocation in his phone. Mr. Bloodworth, objection, Your Honor, foundation. The court, I don't know whether this witness would have the basis to know that, so sustained for now if you can lay some foundation. Ms. Nestor, I understand what you're asking. He's telling you to lay foundation. Question, Nestor, as you've been preparing for this case, have you been reviewing the demonstrative exhibits, no, the demonstrative evidences, Jesus, the demonstrative evidences, that's going in the dictionary. I know it comes from Nestor, but evidences is going with exhibities. Because the demonstrative evidences is hilarious. The demonstrative evidences, demonstrative exhibits that the state prepared to get ready for trial. Answer, not all of them, and not this one. I've just seen it in court. Question, okay, did you, as the head investigator of this case, investigate Eric's whereabouts on the day of February 14th? Answer, yes, in the sense that Mr. Kotrodemus, the digital forensic expert that the county hired, helped us in the analysis of the phones, and he at some point told us the data that was in the phone regarding Eric's location on the 14th. And remember, we were talking about ask whose job it's not? Because if you ask Mr. Kotrodemus, and I keep trying to not default to Kolakithis, but when we talked about this in real time, it was the ask whose job it's not, because the tech expert would have been able to hand them a whole lot of information. And that's not exactly, I think, what they were looking for. My speculation. The answer, the tech expert told us what it said. Right. Question. All right. So without revealing anything that Mr. Kotrodemus said, what did you learn about Eric's location that informed how you acted in the future of your investigation? Can you give me the information that he told you without telling me that he told you? Bloodworth, objection, foundation. I don't know how he could know without hearsay. The court, well, it's possible that he heard it prior to being in court, and to the extent that it is to inform what he did next, we can accept that it's not for the truth of the matter. Shall we proceed in that way? Ms. Nestor, yes, Your Honor. Mr. Bloodworth, let's see what the response is. Nestor, go ahead. Answer. Just so I'm clear, you're asking if I'm aware of Eric Richins' location on February 14th. Yes. Answer. Just based on question, the whole investigation? Answer, the digital evidence. Nestor, yep, the whole investigation, whatever you did. The court. Your question was at least tied in some way to Mr. Kotrodemus. Nestor. Okay, we'll start with that. Nestor. So based on your working with Mr. Kotrodemus, looking at the digital evidence that you went through in this case, do you have knowledge of Eric's locations on February 14th? The court, may we pause a minute? I remember this because it was round and around and around and around. The court, may we pause a minute? Nestor, yes. The court, will you just approach for a minute? Ask whose job it's not. A bench conference follows. So Nestor walks up. Yes, the court. I'm trying to avoid another hearsay mess. I understand what you're trying to do is, and then Nestor says yes, and the court says lay some foundation and then ask him why he did or didn't do certain things. Nestor, yes. Related to Eric's location on the 14th. Nestor, yes. The court, okay. Nestor, that's all I'm trying to get to. The court. And chat, if I read these awkwardly, I have not read these transcripts at all ever. So I do not know. So we're going to find out. I'm going from the footnote to the curiosity. The court. So maybe just ask yes or no questions about whether Mr. Kotrodemus ever gave him any information related to Eric's. Ms. Nestor, he could then use the court right. Nestor inaudible, the court. And then if you want to ask him, did he follow up on it or anything like that? Nestor, perfect. The court, fair enough. Nestor, I'll do that. The court. The substance of the information will be revealed by the yes or no question. Mr. Bloodworth, yeah. We'll see where this goes. Also, on cross-examination, just ask the proper question. Bloodworth, yeah, we'll see where this goes. The court, okay. Bench conference ended. Nestor, may it please the court, please go ahead. Nestor, did you receive information from Mr. Kostrodemus about Eric's location? I think at this point, we should go to the video of this because this is going to lead up to the next sidebar. What do you guys think? We just go to the video? Should we go to the video for a moment? That's got to be the next iteration of what we can do. We've got to go to an iteration where we can pull the video and the transcript up on screen all at the same time. We're not there yet. We might need that in the future. Future problems. All right, let's go to the video. All of you are just like, yeah, it's Friday. I'm ready to be angry. Why not? Why not? We'll just do it. It's fine. It's all fine. All right. I'm going to try to get to that part of the video. This is in the afternoon of day 12 of trial. We are looking at the transcript and we are just after that sidebar where Nestor is trying to find a cross-examination question to try to figure out Eric Richins' location on the February 14th. So let's see. I'm going to try to get that queued up real quick. Let's see. We're going to have to, hold on. We're going to have to jump around a little bit to find that sidebar and then get to this questioning because I'm not sure where it was in the order of things, but I think it was kind of early on in the order of things. So we will see. I think this was kind of early on and crossed to the best of my memory. But it looks like, hold on, chat. We're going to go through this together. I'm going to pull it up on the screen. We're going to find it together. Emily, was this queued up? No. Why not? Well, because I didn't know we were going to be doing it. I was like, all right, I know we're going to get to, there's Carmen Lauber, there's O'Driscoll. I don't know if this is, let's see if this is that sidebar. Nope, this is sidebars about Kouri's mom sending the book from Amazon. Let's see if we've gotten to cross yet. Nope, that's still a sidebar. Let's see.
It was incorrect. You make.
Let's see who we're continuing with. I know, the beard is back. We're good.
Consider Detective O'Driscoll's testimony. Give it whatever weight you see fit.
So in addition to,
we're still in direct. So now we gotta zoom. They're at another sidebar. We gotta zoom past direct and get to cross. Nope, they're still at a sidebar. Emily, every time we fast forward, we just landed another sidebar, apparently. All right, that's still direct. Let's see if we can get to where we're at on cross.
I couldn't find.
is confused about.
Would you just be?
All right, that's still direct.
May it please the court.
Here we are. May it please the court. I think this should be where we are in real time. Everybody's like, we just needed to pull it up to refresh Judge with Beard. Sure. This should be the sidebar we just heard.
May it please the court.
Please.
Did you receive information from Mr. Kostradimos about Eric's locations on February 14th, 2022?
There we are.
That informed your investigation in any way?
I believe so. The truth is, I don't remember 100% for sure if and when I knew about location data from Eric's device throughout the investigation. I would have to go back and review reports, especially Mr. Kostradimos' reports.
Can we, Your Honor,
I just don't remember.
Can we see if this document refreshes your memory as to that?
This one or different
Yes. Can we go through the pages very slowly and give him a minute to see if it refreshes his
Very
recollection?
slowly. Can we go through it slowly?
Yeah, objection, foundations.
Same
But the
problem.
same spot we started with a few minutes ago.
Well, we're showing different pages. He testified that he'd never seen the first one prior to being in the court.
So this is catching us up to where we were in the transcript. Also, I moved things around a little bit earlier, so I'm going to reset. I'm going to reset this real quick. There we go.
It's unclear whether that's true for the remaining pages that the witness is being shown right now. I imagine we're about to find out.
Thank you, Your Honor. Do you need us to do it again, or did you see them all?
Yeah, I saw it.
Does that refresh your recollection about Mr. Richins' locations on February 14th, or what you knew about them?
It doesn't. This demonstrative Mr. Kostradimos created, and the first time I saw any of these slides was in the court. And like I said, he may have shared that information during our investigation. I just don't remember.
Okay. So Ms. Richins is here today on charges that she attempted to kill her husband on February 14th of 2022. Is that right? One of the charges.
I believe so,
Ooh,
yes.
hold on.
And you're the head investigator of this case.
Yes.
Hold on. I have an idea. I have an idea. Hold on. I have a thought. I'm going to see if I can split screen it. Actually, no. I'll wait until his testimony's done, and then I'll split screen it with them. I'll split screen it with them at the sidebar and the transcript when we go to the sidebar. And then we'll split screen it. That's my thought. I'm going to wait until they're done with the testimony, and then we'll do it that way. We'll see if we can do it then. So when we get to the sidebar, we'll do it that way. Okay. I had a thought.
Did you take any steps?
All right. Let's pull this back up. The ADHD impulse took over, and I'm like, let's see if we can do it. No, let's wait. Let's wait until we're done with this part. And then we'll do that. We'll see if it
To
works.
confirm or deny Mr. Richins' movements on the day of February 14th of 2022 when he was allegedly a murder was attempted on his life.
Our team did. We hired an expert in digital forensics.
So what do you know about his locations on that day?
That's what I'm saying. What I know and what I remember are probably two different things. What I knew at some point throughout the investigation is that Mr. Kostradimos probably found whatever location data was available on his phone and shared that with investigators. I just don't remember the contents of what those said.
So as you sit here right now under oath in a homicide trial, you cannot tell this jury what Mr. Richins did on the day he was allegedly attempted to.
No. It's not that he can't tell you. It's that if he told you, it would be hearsay is the thing.
Be murdered. You can't tell him. That's
Foundation, Your Honor. The question is, you can't say what Mr. Richins did. There's no foundation for that.
Your Honor, that's not the question I asked.
I'm sorry. Counsel, just ask a more precise question. And if it needs to be 3 more precise questions,
Thank
that's
you.
fine.
Thank you, I will.
The foundation objection is sustained.
Everybody's getting feisty. Feisty. This is the beginning of feistiness. This is the feistiness. The thing is, the tech expert did it. So he can't say.
And shared that with investigators. I just don't remember the contents of what those said.
So as you sit here right now under oath in a homicide trial, you cannot tell this jury what Mr. Richins did on the day he was allegedly attempted to be murdered. You can't tell him. That's
Foundation, Your Honor. The question is, you can't say what Mr. Richins did. there's no foundation for that.
Your Honor, that's not
It's
the
a
question I
post-location
asked.
discussion.
I'm sorry, counsel, just ask a more precise question. And if it needs to be 3 more precise questions,
Thank
that's
you.
fine.
Thank you, I will.
The foundation objection is sustained.
You cannot say under oath what your investigation showed about where Mr. Richins was on the day that someone apparently
Ask the tech expert.
attempted to murder him.
I could after a 2-minute conversation with the digital forensics expert that we hired, because I
Not
just
my
don't
job.
retain that information well.
So you don't know.
I don't remember.
You don't know right now, and we're in trial right now.
I'm going to try to not give the same commentary I gave when this was going on during trial, but I forgot how much this annoyed me. I'm glad we went back to watch it, though. It's different than on the transcript.
Oh, do you know right now?
Objection, Your Honor, asked it and answered.
I'll withdraw.
That one was a little argumentative, sustained.
I'll withdraw. Speaking of that, were you ever able to confirm or track Mr. Richins and place him to
Also, Kouri trying to signal to the jury, like, can you believe it? Girl, they're asking whose job it's not.
Did you ever
That's
check
exactly
and see
what
if
happens.
he ever went to the house in Midway on his geolocation? Did you ever ask anyone to do that?
Objection, foundation, when?
I can ask him if he asked anyone to do it.
Well, that's a different question. So
that's not what you
the
just
question you
asked.
just asked was very broad as to time frame. Foundation objection is sustained, but please ask a more precise question.
Did you ever ask an expert, hey, can you see if Eric Richins ever went to the Midway house where Carmen allegedly left drugs in a fire pit?
So
YouTube, what are
I
you
was the
doing?
lead investigator on the case. I was not the only one making decisions. I am aware that someone in our investigative team directed Mr. Kocher-Demos to look into Eric's location from his device. Yes.
Are you able to tell this jury if Eric Richins was anywhere near the Midway house around the time that Ms. Lauber claims she left drugs there?
That's a broad date range. So I don't know. I don't have that data in front of me.
Okay. All right.
Also, did you see after the prosecution was like, objection, that's broad as to date? The next answer from the detective was, that's a really broad date range. He's like, I'm not really sure. But also, he can't testify to what the tech expert told him. You have to ask the tech expert, and Nestor chose not to do it. And this is where you end up.
Is it true that through all your interviews with Carmen and your attempts to corroborate what she was telling you, at least one of the times that Carmen allegedly
Corey's face is
purchased
just
drugs
facing.
from Mr. Crozier and brought them to Kouri was after Eric was dead?
Her testimony was not that. She didn't remember it that way. We found digital evidence that suggested that.
So after Eric died, it is your understanding that there's still drug dealing going on between Kouri and Ms. Lauber?
Purchasing.
I am aware that Miss Lauber conducted a similar transaction to ones prior to Eric's death, after his death with Miss Richins.
On that, that's the occasion, I believe, and you were here, if I'm wrong, please correct me, but that's the occasion where Ms. Lauber claims that Kouri had to write her a check, right?
Yes.
And the check was written out on the Kouri Richins Realty checkbook, right? As you recall from your investigation.
Yeah, I believe it was K. Richins Realty check.
Did you do any corroboration or investigation into whether or not Carmen Lauber did actual work for Kouri Richins Realty that week?
That is a good question. That one's a good question. That one's a good question. 1.
Yeah, I mean, we talked to Carmen.
I mean, they did ask Carmen, and Carmen said, no, I wasn't doing any work. I was just giving her drugs. But it's a good question.
About her relationship with Kouri in all ways. And she said she had done some work for Kouri in several different capacities. As far as that week, I don't know that we ever got into those details.
That was the week that they were about to close on the Midway Mansion. Is that correct?
And the prosecution had asked Carmen Lauber about this, anticipating this line of questioning. I think by this point of the trial, because this is almost the very end of the trial, this is the last witness, I think that had kind of been lost. For those of you just popping in, Emily, are we rewatching parts of Kouri Richins' trial? We're trying to see what led up to Judge M telling Nestor to slow her roll at Sidebar so that we can get to the Sidebar.
What date are you referring to?
The date that.
Because context.
I'm sorry, strike that. That's fair. The week before she got the check is the week that the Midway Mansion closing allegedly happened, right? Right after Eric's death.
Your Honor, objection. The air quotes, this is testifying.
The air quotes were for the Midway Mansion. That's why I did that.
Apparently Nestor is air quoting. At least she didn't air quote investigation.
I understand.
That's what I call it. But for the House on Legacy Drive, I won't do that again. The House on Legacy Drive.
Sorry, can you restate the whole question? I've forgotten it already.
The House on Legacy Drive had.
Okay, deadass, that would be me. Like, what the fuck just happened? I'm sorry. I was watching you two fight and I forgot what you asked me.
That's what I call it. But for the House on Legacy Drive, I won't do that again. The House on Legacy Drive.
Sorry, can you restate the whole question? I've forgotten it already.
The House on Legacy Drive had closed in between Eric's death and when Ms. Lauber allegedly got this check, correct?
Between Eric's death and when she got the check?
Right.
As far as my understanding, yes.
Did you ever talk to the realtor and say, hey, did Carmen Lauber clean up that house the week before it closed?
Which realtor?
No, because Carmen Lauber didn't say that she did.
The realtor for the Legacy house.
I'm not aware who that is.
You don't even know who was selling that house?
No.
So I guess the answer is no, you never made any attempt to corroborate whether Carmen did work that week.
Well, they asked
I don't know
Carmen.
that the realtor would know the answer to that question, but I never talked to them.
Okay.
I mean, they asked Carmen.
And speaking of the Midway Mansion closing, we've had some testimony here about some closing documents that were signed and dated either the day after Eric died or a couple of days after Eric died. Did you hear that testimony?
I believe so, yeah.
Did you ever go to the people that conducted the closing and confirm whether Kouri was present at that closing in person?
No.
Are you aware that you can do closings on houses without being present in person?
I know nothing about realty.
Okay, well, then I'll let you have a pass on that. Did you ever do any determination as to whether those documents were signed through what's called DocuSign electronically?
I mean, they can be signed through DocuSign and she can still be present.
I'm sorry, can you say the question again?
Does
The
it matter?
closing documents for the Legacy property, did you ever do any confirmation or investigation into whether those documents were signed via DocuSign or electronically without being with a wet signature and a pen?
Oh, that was a rude pause. Hold on. Also, if you're the prosecution in this case and you have the financial expert that you have, you're not asking O'Driscoll to do any of that. O'Driscoll, as a detective, moved from narcotics to homicide, doesn't seem to have ever worked in fraud. I would have 100% asked the financial expert, who was so good, all of those questions. Right. I wouldn't have asked O'Driscoll to do any of that.
The investigation into the signing on the house and the other financial documents, I wasn't a part of. That was through the prosecution's office's investigator and their experts, their forensic accountants.
But
I wasn't really part of that.
As lead investigator, you can't testify that that was
Because they split up their lead investigators. Yep.
ever done here today.
I have no knowledge of it.
Okay. You did,
I'm
you were
curious
involved
to
in
see
at
when we get to
least
that sidebar.
8 of the 10 search warrants that were issued on this
I
house?
didn't want to speed her up.
Because I think
Now
the
I'm
first 2
regretting
were
that choice.
Detective
What do you
Woody.
mean by involved?
You were lead investigator once those warrants were being executed?
We're almost there. We're on page like 144 of the transcript.
I think the first 2 were Woody, so I don't want to credit those
The
to you.
title of lead investigator doesn't necessarily mean what I did in those circumstances. I guess I would ask you to be a little more specific
We're
about what
almost
you're
there.
asking.
How many warrants are you aware were executed on the house, on the Richins home?
I believe around 10. I don't remember the exact number.
And in 10 different times of searching, was there ever any fentanyl recovered?
I wonder if this is a difficult question because there are still lingering questions about some pretrial rulings. And there were things like the tweezers that we never heard about again. And so I'm wondering now in hindsight if the tweezers, it'll be interesting when some of those motions are unsealed. Like if the tweezers that we heard about tested presumptively positive for fentanyl, but we never saw it in the trial, the detective has to parse out not fucking it up. Because if he says, oh, you mean the tweezers? They had fentanyl on them. That can cause a mistrial. So he also has to parse what the pretrial rulings are and not step in it, because that would just mistry the whole case on the last witness.
Throughout the 10 search warrants, anything that was recovered during those search warrants that we suspected may contain fentanyl, have traces of fentanyl, were sent to the state lab.
Okay.
We got results back from the state lab. There were some items that.
Your
Your Honor, may we
Staff.
approach?
Okay.
Oh, right. Your Honor, may we approach?
Do you want to move on?
Yeah.
Okay.
Right, to not step in it from the pretrial rulings.
In the 10 search warrants that were executed on this house, did you,
I'm going to speed this up because we're almost there, but we're not there enough.
ever find any cups, glasses, straws that contained any traces of fentanyl on them?
Let me be clear. I wasn't present at every single time that the house was searched. So the answer is investigators on my team or investigators from the Summit County Sheriff's Office did not find cups, straws, the things you mentioned that contain fentanyl, no.
And this is what's difficult too, because if there are pretrial rulings keeping out like tweezers, and so she's asking cups and straws, at some point it gets very frustrating on just the prosecutor side, because it's like, well, Your Honor, it's leaving a wrong impression that nothing had traces of fentanyl. Things did, just not those specific things. And that becomes where you have to be careful also as the defense to not open the door to be like, well, you've left an impression that nothing in this house had traces of fentanyl, and that's not true. I kept it out at pretrial, but now you've opened the door for it.
As you sit here today, can you even tell this jury the exact time that Eric Richins died?
I don't know that anybody can.
Can you tell this jury how fentanyl got inside of Eric Richins? Based on evidence, not speculation or theory, but evidence.
I know it was orally ingested.
And that's all you know, right?
That's not all I know, but I know it was orally ingested.
Kouri's face is facing so hard. That's
To
not
this
all I
date,
know.
have you ever recovered any of the pills that Carmen Lauber allegedly gave to Kouri Richins to test to see what they are?
That I can confirm for sure are the pills that passed from Carmen's hand to Corey's hand.
Correct.
No.
Okay.
I'm going to zoom past a little bit of this line of questioning to get just a little bit further down this transcript to get to them at sidebar. because I forgot how round and round and round and round and round and round and round it went.
Probable cause standard for the arrest of Ms. Richins.
Okay.
We gave that information to the prosecutors, and they filed charges in this case. They then requested an arrest warrant be issued from 3rd District Court. I executed that warrant by arresting Ms. Richins.
Have you ever heard of hair follicle testing?
I think I've heard that term. I don't know what you're referring to.
What's your knowledge of it?
That people much smarter than me can test hair follicles for what it can tell you about the body's biology. About the
Specifically,
extent of what I know.
specifically, isn't it fair? You've been a narcotics officer for a long time.
Objection, Your Honor, relevant scope.
This is beyond the scope,
Your Honor, goes to the investigation or lack thereof.
but beyond the scope of the version, or the version of the direct examination regarding the investigation. You have other options to get into this. It's just not right now.
Okay. Court's indulgence for just a moment, Your Honor.
Of course.
The defense is conferring with each other. The defense is having a full conference with all of the defense attorneys and their investigator. I'm going to zoom past that.
Searched Carmen's.
This is still sped up.
When you searched Carmen's house, did you test any pills that were found in Carmen's house?
I don't remember. That would be a better question for Ms. Gibson. She handled all the evidence recovered from that search.
All right. I'm going to skip a little bit past them going through Carmen Lauber's house to try to get us a little closer to, again, the slow your roll sidebar. This is taking a minute.
Check in with her? Went by and saw her at her house?
This is regarding the probation of Carmen Lauber.
Need answers, Steve.
I'm sorry.
You gotta say yes, because they can't type.
Right.
Okay, so what was the answer to the last question about you called her on the phone?
Yes.
You would go by and see her in person?
Well, not just like to see her, but like if we needed to get in contact with her in person for some reason, yeah, sometimes we would go to her house or her work, wherever she was at.
In this relationship or these,
All right, this is about Carmen's probation. We're going to zoom a little bit because I'm trying to get to that sidebar.
so clearly, I would imagine, as the lead investigator, if you're investigating a potential homicide, would it be important to you to look at the very last conversations that the decedent and the suspect had right before the death?
It could be part of it.
Did you do that?
I believe I did. I don't remember what the contents were, but
Katie, can you please pull up JO11? JO11?
I'm going to zoom, see if that gets pulled up.
Conversation he had with his wife, right?
that's what.
This is getting into those text messages before we get to that sidebar. I remember this. They were trying to figure out what some of those text messages were, and whether or not they were going to be admitted.
So that's where we got the information about.
So again, trying to get back into the technology without asking all the people that were in charge of that. Ask whose job it's not.
The hunting guide in Mexico. So yeah, we were looking at that information.
So then, Your Honor, may I please admit this as Defense Exhibit 300, I don't even know what we're on yet. 3010. Is it 10? It's 3015. We're a little behind. Thank you, Ms. Brittany. I appreciate that. We move to admit it.
Well, objection, foundation, or authenticity. I'm also looking at maybe approach.
Yeah.
Yeah.
Can we go to the...
May we approach? Yeah. And now we are finally getting to the slow your roll sidebar. So let me see if I can split screen this video with the transcript so we can look at them side by side and see what happens at this sidebar that the defense is complaining in footnote 1 at the very end of the day of day 12 of trial. We're like last witness, end of the day, day 12. And this is what they choose to lead with in their footnote regarding the court telling Nestor to slow her roll and saying, I've got to move this along. So let's see if this worked. Chat, fingers crossed. All right. Okay, there we go. We got a bit of a split screen. All right, I can't pull this up. Let's see if I can embiggen this a little bit. Oh, will it not let me zoom? Oh, wait, nope. There we go. A little bit of a zoom. A little bit of a zoom. That's helpful. Huzzah. It'll work. It'll work for now. All right, I'm going to mute this as they go up so we don't have to hear the crackling.
Is this the first page, Katie?
Background. But I'm going to turn that down as they approach. All right, the court said, is this the first page, Katie? And I'm going to read it along, and y'all can watch Kouri's face facing while I try to read along this sidebar that's, oh, I should slow this down because I definitely can't read in 1.25. All right, we got to, is this the first page, Katie? A bench conference was held outside the hearing of the jury. The court, I don't have a basis to say that this is authentic. Where's the celebrate header? Ms. Nestor, Your Honor, we had a huge discussion about this, that you promised me that we did not need the celebrate extraction put in to get the text. The court, not the extraction. How is this from celebrate? Ms. Nestor, yes, it's Mr. Bloodworth. It's not, Your Honor. That's the whole problem. So at sidebar, they are looking at whatever the defense wants to admit, and this was not allowed to be admitted. They're looking at whatever the defense wants to admit as exhibit like 305 that did not get admitted. The defense is saying we had a discussion about this, that we don't have to have the entire celebrate extraction to have the texts. And the court says, is this from celebrate? Nestor, yes, it's Bloodworth. It's not, Your Honor. That's the whole problem. The court, oh, okay. So this is what's going on at sidebar. Mr. Bloodworth, you can see that the time zone is off. This is very, very early state production based not on celebrate extraction. The celebrate extraction and the production of a celebrate that was authenticated. The foundation was laid by Coaster Demos for authentication. That's all in the right time zone, UTC -6 or 7, depending on daylight savings. That one reads to be UTC 5, which tells me it's from an earlier unauthenticated extraction. Ms. Nestor, I have the celebrate version. If you give me 5 minutes, I can use that instead of this. This is their discovery given to us that we have all agreed I don't have to authenticate celebrate. We've had a huge discussion about that. The court, you're misremembering our discussion. Our discussion was that you don't need to put into evidence the raw data. Ms. Nestor, right. The court, is this an authentic output of the celebrate extraction? Ms. Nestor, yes. The court, and you haven't laid foundation for that. Where's the header? So the problem is the defense is trying to put in an earlier extraction that there's no foundation for because the state didn't use it. The state did not use the earlier celebrate extraction. And as I remember from pretrial hearings, the defense was objecting with regard to how the state's crime lab got into Kouri's phone the first time. And so they went back in and did a full separate extraction at the lab. That separate extraction is the only one that was authenticated during trial. They turned over all the previous work to the defense, but they didn't authenticate it with their witnesses during trial. And if the defense wanted that authenticated, they needed to ask those witnesses about those base exhibits, that full extraction, and they didn't. And the reason that I wonder if the reason that they are trying to use the one that's in the wrong UTC is because the timing is more helpful. Because we all know that when you're looking at UTC, the time zones matter, and the difference between whether you're in UTC or whether you're in Eastern or whether you're in Central or Mountain or whatever can make a very big difference. And if you get the timestamp wrong on, say, a text or a tweet, it can look like an incredibly different situation because the time is off by 1 or 2 or 3 hours. And that leaves a lot of mess. But also, the defense can't put in messages from an extraction that wasn't authenticated. And this is what they're complaining of. This is what they're complaining of in their motion. Let's go back to that. The court said, "You're misremembering our discussion." Oh, let me keep rolling that. "Our discussion was you don't need to put into evidence the raw data." Nestor, right. The court, "Is this an authentic output of the Celebrite extraction?" Ms. Nestor, "Yes." The court, "And you haven't laid foundation for that. Where's the header?" Ms. Nestor, "I'll get the Celebrite version. We do have it. If you give us just a 5-minute break, maybe." The court, "I also have another question. Is this within the scope?" Ms. Nestor, "Your Honor, maybe. I object to you providing the state with their objections. I object to that." The court, "Oh my goodness." Girl. The court, oh my goodness. He's trying to handle all of the potential problems. And instead of just talking about the extraction, she shifted tactics to, "I'm not going to answer if it's within the scope, Your Honor. I object to you providing the state with their objections. I object to that. I object to your objection, Your Honor. Objection." The court, "Oh my goodness." Ms. Nestor, "I do." The court, "Do you want to go back and read the ruling that I issued yesterday to try and avoid plain error to help your client?" Ms. Nestor, "Your Honor, we appreciate that, but..." The court, nope, I'm going to try to roll this. They're only showing O'Driscoll while this is going on. Ms. Nestor, "Your Honor, we appreciate that, but..." The court, "So please, let's slow your roll on that one. I just want to make sure I'm not creating the same hearsay mess that I created 2 days ago." So he's telling Nestor to slow her roll on objecting to an objection of an objection. Right. The court, "So let's make sure we're careful about this. I need an authentic version of this, and we'll go from there." Ms. Nestor, when you say authentic, I just want to make sure I get what you need. You want the one that has the Celebrate heading on it because we have that. The court, "Well, let's start there." Ms. Nestor, okay, I can do that. The court, "Okay." Ms. Nestor, "But I'm going to need 5 minutes." The court, "Well, you've got to wrap it up for today for, among other reasons, I have a parent-teacher conference to go to and my son barely recognizes me." Ms. Nestor, "I understand." The court, "So if you want more time with this witness," Ms. Nestor, "I do." The court says, "On cross tomorrow morning, no problem." Ms. Nestor, "Yeah, let's do that." The court, "Any objection? Let's do that. And that will give you time to maybe even have a conversation with Mr. Bloodworth about whether this is the correct version of those messages." Ms. Nestor, "I'm confident that it is, but we will take care of the Celebrate. We'll get it to you, and I can get it to you tonight." The court, "It's not me that you need to talk to." Ms. Nestor, "Right." Court, "Okay, very good."
Pause there.
The court, "Let's pause there." And then that's it for the day. So they say we need time. The defense says we need more time to pull this together. And the court says, okay, we need to wrap this up because, among other things, I need to get to parent-teacher conferences. So you handle this overnight. We'll bring this witness back in the morning, and then we'll handle it in the morning. We'll give you time to get this prepared because the court knew it wasn't going to be 5 minutes. Take your time, get what you need, finish cross in the morning. And then the court gave them like a whole weekend plus to do their closing. Imagine knowing this context and then putting in a footnote that the court was rushing her along because they had a parent-teacher conference to get to. The fucking audacity. And he was giving them more time because it was never going to be 5 minutes. And he said, do I need to give you time to go read the ruling from yesterday? Because what you're trying to put into evidence isn't valid evidence. And you know what happened the next day? They never put it in. Absolutely wild. Where's that footnote? Hold on. I've got it on two. We have too many tabs. We have too many tabs. Hold on. Where did the defense's motion go? Where did I pull it up? I'm going to get back to that footnote. Now that we've read the transcript, we can actually take a look at that footnote with a little more context. At the bench, the court angrily criticizes Ms. Nestor's objection, telling her to slow her roll and reminding her that too, their typo. Read the ruling that I issued yesterday and try to avoid plain error to help your client. Further, the court tells Ms. Nestor she needs to wrap it up because, quote, I have parent-teacher conference to go to. That doesn't even accurately quote the transcript. I have parent-teacher conference to go to, and my son barely recognizes me. Well, you've got to wrap it up for today, among other reasons. I have a parent-teacher conference to go to, and my son barely recognizes me. That's not the same. The absolute audacity. It's just so, it's just such fuckery. It really is. And there's absolutely no need for it. And after how painful that cross-examination was, I'm not surprised that the court was like, hey, go read the ruling, go get the documents, give yourself overnight to prepare, talk to the prosecution, and let's go. Absolutely wild. But wait, there's more. Footnote 2. See the attached video clip of trial day 4, page 207. The court interrupts Miss Lewis in a demeaning manner, saying, please pause. Seconds later, the court follows an interruption of the prosecution with an apology. When Miss Lewis expresses frustration at the court for changing a ruling made at the bench, she is told twice to stay focused and don't do that. Please stay focused. So where are we going now? Day 4. We need to go to day 4 because what we didn't know is what the fuck happened at that sidebar on day 4. So that's what we're going to do. All right. Let's go take a look. We have watched after the sidebar, we've watched this play out, but we don't know what happened at sidebar that caused all of this. So let's see, what day are we on? Day 4. I'm going to pull that up real quick and we will try to find the proper sidebar. If I am remembering, because the last time we read this footnote, we just rolled the tape of what happened after the sidebar. And they were talking, I believe, about Carmen Lauber then too. So let's go to page 207. Let's see. I am looking at, before I zoom us to the right page for the sidebar, hopefully. We are looking at day 4 of trial. And we are looking at, let's see, which witnesses are we looking at? We are looking at, let's see, Chelsea Gibson, Brianna Peterson, Frank Root, Cheney, Eng Tao, Brian Holden, and then the beginning of Carmen Lauber. So memory does serve. We are going to page, what did they say, 207? So let's zoom. And then if we want to roll the tape of the fallout after the sidebar, we can always do that again and see if it really is all that Miss Lewis cracked it up to be just one more time. But I want to see what happened at this sidebar, because this was also, to my memory, a foundational issue. Let's see. Shockingly, it doesn't seem that sidebar starts at page 207. So we're going to have to just back up a little bit. This is during let's see. This is during the testimony of Carmen Lauber. Let's take a look. Let's see. Did you ask Kouri Richins about Eric's death? Yes, I did. Question. What did you ask her? Answer. I said, please tell me these pills were not for him. Did she respond? She did. How did she respond? She said, no, they were not. Eric passed away from a brain aneurysm. So this is the part of Carmen Lauber's testimony we're in. Mr. Bloodworth, Scott, can I get 2-44, please? If you look down at that column labeled description, Ms. Lauber, do you recognize that as a text exchange between you and Kouri Richins? Yes, I do. Is this an accurate text exchange, an accurate depiction of the text exchange? Carmen Lauber, yes, it is. And did it occur on March the 7th or March the 6th into the 7th? Does it accurately show the type of messages and whether it's an incoming message or an outgoing message? Yes, it does. Your Honor, the state moves 2-44 into evidence. Ms. Lewis, objection, Your Honor. The Celebrite extraction has not been admitted into evidence, and she cannot identify a Celebrite extraction where it came from. The court, please. And then a bench conference was held outside the presence of the jury. Here's where the defense is. Actually, it's really interesting to look at these two back to back, because it's the same issue on different sides of the coin. The reason that the defense couldn't do what the prosecution is doing here is because the defense was asking O'Driscoll. You can ask two parties of a text conversation and say, read those texts, are those your texts? It doesn't matter if you're reading it off the screen of a phone or if you're reading it off an extraction. Are these your text messages? Did you write these? Did you read these? It doesn't matter. It's like, is this you in this? Look at this photograph. Is this you in this photograph? Do you know where it was? It doesn't matter if you don't know how the photograph went from digital to print. It doesn't matter if you don't remember who took the photograph. Look at this photograph. Is that you? Who are these other individuals? Do you know where this is? You can authenticate things from being present. And so the difficulty the defense is having here is that with O'Driscoll, they're trying to get O'Driscoll to authenticate a Celebrite extraction when he was not a party to the messages and he didn't extract it and he wasn't the examiner. So they can't do that. But a party who is a part of those texts can absolutely say, yes, these are the text messages. She's not authenticating the extraction. She's authenticating the conversation in the text messages. So then the jury wouldn't see the headers. Like, you can't show the jury the headers, but you can show them the body of the text. So that's where we're now in a quandary for the defense. The court, please. A bench conference was held outside the hearing of the jury as follows. Oh, and this is when they kicked everybody out and then continued. The court. Why isn't her sworn testimony sufficient foundation to admit the things that she just testified to? Miss Lewis, I'm sorry I didn't hear the first part of what you said. The court. Why isn't her sworn testimony just now sufficient to admit the information that she just testified to? It is. It is sufficient. The problem is that it is sufficient. The defense is just struggling with the rules of evidence. It's sufficient. You guys want to watch the sidebar as it's happening? We want to try to split screen it again? I can do that. It'll take me a second, but we can do that. Gabe in the chat said, let's watch it. Well, Gabe, it's great. It's a great suggestion. Chat's like 100% yes. All right, we'll cue it up. Give me 1 sec. Let me find that sidebar. Let's see if this is the correct sidebar. And we will, because I have day 4 queued up from the last time we watched day 4, which is helpful. Okay, we're just going to rearrange things on the screen real quick. And then, oh no, I just closed damn it. I closed the wrong tab. Hold on. I got to go grab the transcript again. It's okay, chat. That's 100% a skill issue. That was a skill issue on my part. Don't tell Griffin. I'll never live it down. Me, when we're traveling, I'm like, oh, I forgot XYZ. He's like, sounds like a skill issue. I'm like, thanks, buddy. Sounds like there's a lot going on issue, but sure, I guess that's still a skill issue. Okay, let's see. For what it's worth, the sidebar she is quoting as starting on page 207. The sidebar actually starts, shockingly, before that. So we are going to go to where the sidebar starts before that, after the objection with regard to the text messages in March. So let's see. All right, this is, I think, where we are queued up on the transcript. Let me grab the video and we'll be ready to go. Because live streaming's dynamic and chat's like, roll the video. And we're going to roll the video. Because it's Friday. And because court was super short today. So now we get to do what we want. And look at a few sidebars. All right. Let's see if we are queued. Let's get ready to rumble. Let's see if we are queued up in just about the same spot. We should be. I hope that we are. Hold on. My Google Drive is fighting with me. Actually, no, I'm not going to try to open this in a different. It'd probably be easier if I did. But next time we do this, and I'm going to go in side by sides, I'll probably open this in a different viewer just so it's a little cleaner. But for today, this version works just fine. We've learned new things. Look at us, chat. We get to do new things. All right, here we go. Perfect. Nope, wrong way. This way. There we go. That works. All right. Emily fights with technology. All right. Let's see where we're at in the testimony. I think we're just about right.
Ms. Lauber, do you recognize that as a text exchange between you and Kouri Richins?
Yes. Yes, I do.
I love it when a plan comes together. Woohoo!
Is this an accurate text
Are we trial day
exchange?
4?
An accurate depiction of the text exchange?
Yes, it is.
And did it occur on March the 7th, March the 6th and into the 7th, 2022?
Yes, it is.
Perfect. I'm just going to let that roll.
Does it accurately show the type of message and whether it's an incoming message or an outgoing message?
Yes, it does.
Does it actually accurately show the sending party, the from party and the receiving party, the to party?
Yes.
You guys, the lawyer who has a better command of the rules of evidence is always going to have a better time at trial.
2-44 into evidence.
Objection, Your Honor. The Celebrate extraction has not been admitted into evidence, and she cannot identify a Celebrate extraction where it came from.
But she can identify the text messages. You need to review the rules of evidence.
Please.
The court sounds so defeated in saying, please. I'm going to turn down the volume on this. The court says, please. The court, why isn't her sworn testimony sufficient to admit the things that she just testified to? Ms. Lewis, I'm sorry, I didn't hear the first part of that. The court, why isn't her sworn testimony just now sufficient to admit the information that she just testified to? A text message exchange beginning on the 6th into the 7th between me and Kouri. This is the description of the exchange is an accurate representation of what I remember. Ms. Lewis, because the Celebrite extraction actually needs to be admitted into evidence, she's wrong. And she's not qualified to authenticate that or to talk about it in any way. I guess if she wants to talk from memory about a cell phone text conversation she had, that's exactly what's happening. But we object to it coming in this method through this witness. The court, well, isn't it a summary? Forgive me. There are rules for summary exhibits, by the way. The court, why isn't it a summary? Forgive me, I can look up the rule for it. Why isn't it a summary of other data that she can testify to? Ms. Lewis, I don't think it matters if it's a summary. It has to come in through proper methods, and she's not the proper witness to enter Celebrite extractions from. Round and round and round and round and round and round and round. The court, if the word Celebrite is not on this thing, if it were just typed out and handed to her, does this match your recollection? Is this a demonstrative of what you remember? What would your objection be? Ms. Lewis, well, these didn't come from her phone. The court, please answer my question. Do you see what the defense keeps doing? They keep bridging into answering not asked. Right. Ms. Lewis, well, these didn't come from her phone. The court, please answer my question. Ms. Lewis, same objection. The court, I don't understand your objection to my hypothetical. Ms. Lewis, because it came from the Celebrite extraction, which the court, but that's not my hypothetical. Ms. Lewis, it's not in evidence. The court, please talk about my hypothetical for a minute. Ms. Lewis, well, where else? Where did it come from? I guess I need more information to respond to that. Where did it come from? The court, I guess what I'm asking is, how is this different than a photograph that she didn't take? Exactly. Exactly, Your Honor. That's exactly the situation. That's exactly it. Because that's exactly the scenario where this comes up all the time. Is a photograph that somebody didn't. I am fucking delighted. I am delighted. Exactly, Your Honor. That's exactly the scenario. Emily, why are you so delighted? Because my brain remembers information based on fact patterns, scenarios, song lyrics, vocal stems, and movie quotes. So this is the pattern that comes up all of the time, which is you can use photographs that someone didn't take. It's the same thing with a text. And I love that the court is on the same wavelength. Oh, and this is why I don't pre-read things when we're going to cover them, because I want to just give you my thoughts on it before we get there. I'm fucking delighted. Look at this photograph. Ha! Yes, Your Honor. Same scenario. I love that our analogies are lining up. I love it. Oh, I love it. Okay. So the court shifts tactics and says, I guess what I'm asking is, how is this different than a photograph that she didn't take? Because the court is trying to help the defense recognize that they're arguing the rules of evidence wrong. They're just wrong. Ms. Lewis, so if the photograph that she said, this is what's in the photograph, the court, yeah, I recognize that. I was there. So the court is saying, no, if somebody is given a photograph that they didn't take, that they're in, they can authenticate that photograph. Yeah, I recognize it. I was there. Ms. Lewis, all right, that makes it more clear. I still think, though, if they're not going to bring it in, it shouldn't come in on the Celebrate. She changed her argument. Did you see her change her argument? It shouldn't come in on the Celebrate. I mean, They could show her what was texted, I suppose, and ask if she recognized it. That's literally what they fucking just did. That's what it just did. That's what they just did. She's changing her argument. Well, Your Honor, I guess it's the same. The court, it can't come in as evidence of what was extracted from the phone. It can only come in as evidence to her memory. Lewis says, well, I think that's confusing because it is coming in and the jury's going to see it as extracted from the phone. The court, I should resume this. The court, we can have that conversation, but what's currently depicted on the screen is a summary and, Ms. Lewis said, of what was extracted from the phone. Now I know the court said, it doesn't have the word celebrate on it. Ms. Lewis says, yes, it. And the court said, take a look at the screen. Court, will you please look at what we're talking about? Take a look at the screen. Ms. Lewis, but they have the same text and bubbles. They can show her the bubbles. I don't think it should be coming in for the jury where it looks like an official report that has not been admitted to evidence. That's different. I think that's confusing to the jury that this is an official report. I mean, she's not even testifying from memory. She's reading it off an official report, but that's for cross. The court, would you be more comfortable with the bubbles? I think it's going to be a little harder for you to cross-examine the bubbles. Miss Lewis, I do think there's got to be some foundation as to where this came from. The court says, well, I think the form that it gets published to the jury matters. If it's just like this and it's, does this accurately represent your recollection? I mean, if there, Miss Lewis said, then we don't. Mr. Blower said, but it's also, I don't want to switch cart and horse necessarily, right? But the whole report's going to be, it's going to come in anyway when we call Costa Demas. I mean, it's really a sequence. I think everything the court said is right, and this is Bloodworth. I mean, it is what it is. The conversation is what it is. And if she recognizes it as accurately depicts the substance of the conversation, that's all. The court says, yeah, on cross-examination, you're allowed to say, wait a minute, if I don't show this to you, do you remember it sitting here today? Miss Lewis, right. But if it's all going to come in through Costa Demas, it should come from him first. And this is why Bloodworth was like cart, horse, sure. She's trying. Lewis, right. But if it's all going to come in through Costa Demas, it should come in from him first. I don't see how they can put extractions in through this witness. Why can't they just ask her the question? Tell me what you said in those texts. If it's because he's right, Costa Demas is the one that can introduce it, not her, the court. And so it's the source of the information that you're concerned with, not the content. Miss Lewis, well, if she testifies to what she remembers, sure, the court, but they can refresh her recollection with it. Miss Lewis, okay, yes, but not introduce it. So Miss Lewis is trying to set up a scenario where they don't show Carmen the texts and say, do you know what you texted? Because Miss Lewis knows that Carmen's going to be like, whatever my phone said, I texted her. Like, I don't know. I don't know exactly the words that I said verbatim. I could show you, like, my texts are here, which I think most of us would be like, can you tell me what you texted yesterday? I mean, I can give you an overview, but can you just give me my phone and then I'll just tell you I said that. Or I can look at it and be like, okay, I said most of that, but where it says ducking, I didn't type ducking. What, like autocorrect was wild for that. That wasn't me. So she's trying to get into a situation where they are limited in what they can show Carmen at this point. And that puts the defense in a better position if Carmen hasn't reviewed these when they get into cross-examination, because then the defense can argue with Carmen a little bit more without the jury having seen the text between Carmen and Kouri, because the text between Kouri and Carmen are exactly what they are. And so the defense is trying to limit what the jury sees of Carmen and Kouri's interactions before they get to cross. So she's trying. The strategy behind what she's trying to do makes sense. She's just wrong on the rules of evidence. And it seems to me like the court is trying to help her here and walk her through the different avenues that the prosecution could just enter this in, and is trying to help the defense see that there's not just one door to go through here, and there's a lot of options to the prosecution. So Ms. Lewis wants her to go off of memory, not off of, yeah, those are my text messages. The court, but they can refresh her recollection with this. Ms. Lewis, okay, yes, but not introduce it. The court, okay. I'm going to resume them talking at the bench while I'm reading this. Okay, yes, but not introduce it. The court, okay. Mr. Bloodworth, the source doesn't matter. If somebody else takes the photograph, but you were there and saw the photograph, the court, yeah, no, I know, but that would be based upon, yeah, no. Ms. Lewis, she wasn't there and saw the extraction. No, Ms. Lewis, she wasn't there and saw the extraction. She was there on her phone with her fingies texting it. Ms. Lewis, she wasn't there and saw the extraction. The court, but when she was there and saw the text messages. Ms. Lewis, well, those aren't that. That's the extraction of the text messages. Your Honor, she might have typed the text messages, but she never was there to see the extraction of the text messages. And that kind of circular arguing makes me want to lose my ever-loving mind. I can see why Bloodworth is just like, I don't know how to fix that for you. This is sure, we're just going to go in a circle. The court, but she was there and saw the text messages. Miss Lewis, well, those aren't that. That's the extraction of the text messages. The court, and I'm going to resume the sidebar. The court, well, it's the content, Mr. Bloodworth. It shows nothing but the substance of the messages. Miss Lewis, well, then Mr. Bloodworth, not the additional information. The court, the photograph, right, isn't necessarily taken on the day, in the moment, the event in question. So I understand your concern. This can be published as demonstrative of her memory. It's, I think, the Celebrite report, to your point, but will need to be admitted through Mr. Kostradimus. I think the court's being overly cautious there, actually. I don't think the court would have to wait. I think the things that the court would take out is any like digital identifiers or the fact that the report says Celebrate. But I think the text messages can come in. I think the court is being cautious. The court said, I understand your concern. This can be published as a demonstrative of her memory. It's, I think, the Celebrate report, to your point. I'm going to push play again. The Celebrate report, to your point, will need to be admitted, through Mr. Kostradimus. Miss Lewis, yes, but I don't think this can be admitted. I think it can be used to refresh her recollection. She's not even listening to the court. He said you're going to have to wait to admit it. It can be identified and admitted later. Miss Lewis, yes, but I don't think this can be admitted. I think it can be used to refresh her recollection, but I don't think it can be admitted through her, this report. The court said, why can't it be a demonstrative of her testimony? Miss Lewis, I'm sorry, what? The court, why can't it be a demonstrative of her testimony? Miss Lewis, it's not. Well, now we're in circles. Oh, fucking hell. Ma'am, Miss Ma'am, you are running circles in the kiddie pool and then being like, why is it a whirlpool? What? Why is it a whirlpool? I don't understand. Ma'am, because you've been running around in a circle. You made the whirlpool. Well, I don't understand. Oh my God. Okay. Miss Lewis. Well, now we're in circles. No one else is in circles. Well, now we're in circles. The Celebrite extraction needs to come in through the person who extracted it. That's not true. The court. What is the lack of foundation here? I really don't understand your position. Right, because her position is novel under the law. Ms. Lewis, it's not authenticated at this point. Carmen authenticated it. It hasn't been introduced. It hasn't, who extracted it? Where did it come from? Who authenticated it? None of it's been introduced. I think it's appropriate as an impeachment document. Did you catch that argument? As an impeachment document, it's appropriate for the defense to use, not the state. And what would the defense do if the state didn't bring in all the text messages? They would just go through and cherry pick the text messages on cross-examination without any context, which is why the state wants to put in the full context before they get to cross-examination. So she's now not saying these can't be used. She's saying these can't be used by you. You can't use all the text messages and you can't show them all to the jury, but we can use them on cross-examination in the way that we want. That's what the fight is here. She's not wrong that's what she wants to do. She's not wrong in her strategy. She's wrong about the rules of evidence. So the strategy is not going to work, but it's not going to stop her from trying in circles. Emily, how do you advocate for your client and not end up here? You make your arguments and then you stop. And then you try to narrow it down because the court was on her side a little bit. The court was like, right, well, all of it can't come in. I think where Lewis would have done well is to then push that, okay, well, then if it's just to refresh her recollection, then it can't be shown to the jury. And then you keep it off the screen. I think there was an avenue she could have gone, and she was being pulled in the whirlpool that she had created and couldn't see that off-ramp. So the defense says, I think it's appropriate here. Let's resume what's going on at the sidebar. This is all happening while Carmen Lauber's still on the stand and the jury's still in the jury box. And Lewis says, I think it's appropriate as an impeachment document. The court says, well, if there's no foundation for it on direct, there's no foundation for it on impeachment. Ms. Lewis, well, she can look at it and see if it refreshes her recollection as to what the texts were, but it can't be published to the jury at this time. Oh, see, there's the off-ramp, right? The jury can't see it. The court, okay, let's proceed in that way at the moment. How many more of these do you have, Mr. Bloodworth? Mr. Bloodworth, I think this is it. The court, okay, let's do that with this page at the moment. Mr. Bloodworth, proceed as if it's a demonstrative. The court, no, let's do the refreshing of recollection. Mr. Bloodworth, Your Honor, no, that's not. Ms. Lewis said every time. How can, Mr. Bloodworth said, it's not just not under the rules of evidence. Holy shit. So this is what led up to her fighting with him, because Mr. Bloodworth said, the court said, let's do the refreshing of the recollection and not put it on the screen. The court was just trying to move them along and move the jury along. The court's not right on that. I understand why the prosecutor wants to stand their ground based on everything we just discussed. When has Mr. Bloodworth gotten to make his side of the argument in this entire sidebar? In this entire sidebar, Bloodworth has been standing there sideways while Lewis has been going round and round and round on the rules of evidence. When has Bloodworth has been standing there just sideways while the court went back and forth with Lewis? And then the second Bloodworth says, Your Honor, no, that's not whatever he says we're asking or whatever. Miss Lewis says every time, how can, and Bloodworth says, it's just not under the rules of evidence. And the court says, take a break, go back to your tables for a moment. Miss Lewis, thank you. The bench conference concluded.
Your legs.
And then the court says, ladies and gentlemen, please stretch your legs. And then he excuses Carmen Lauber from the courtroom.
You're taking a break.
And this is where the jury gets a break. And this is the rest of that footnote. Because the rest of that footnote, hold on. The rest of that footnote, let me find it real quick. Where did I put Hold on, too many tabs, too many tabs. Where did I put the motion that they are arguing? 1 second. We will find it. But the rest of that footnote says that, there it is. The rest of that footnote says, the court interrupts Miss Lewis in a demeaning manner, saying, please pause. Seconds later, the court follows an interruption of the prosecution with an apology. When Miss Lewis expresses frustration at the court for changing a ruling made at the bench, she is told twice to stay focused, and don't do that, please stay focused. And now we see all of the sidebar leading up to Miss Lewis saying, but you're changing your ruling. The court didn't make a ruling. The court punted a little bit. The court said, can we just try to do it this way? Can we just get through this part and do it this way? Please, can we just move forward this way? And the prosecution said, actually, no, we can't move forward that way. And that's when, the prosecution was starting to say, no, that's not under the rules of evidence. And Miss Lewis said, what did she say? She ended the sidebar on saying, what, every time? Let me grab that one more time because I'm so befuddled that that was the choice that she was making. Where did it go? Hold on. My transcript, did it yeeted itself? Where did it yeet itself to? Sorry, chat. It's probably in the same screen here. Where in the world did it go? I don't know. I'll find it. We're going to start rolling this, but she ended up with interrupting the court, saying essentially every time. And then the court just was like, pause. Just pause. Hold on. I'm going to have to pull it up again because I don't, honestly, no idea where it went. And pulling up day 4 is not that hard because we were almost there. What? Like it's hard. And then the court excuses the jury. I'm going to roll that while I'm looking for this part of the transcript. The court, I don't even know what's going on. YouTube, stop suggesting videos. All right. Then the court excuses Miss Lauber.
In favor. I need you to go wait in the lobby. Okay? Just for a moment. I need to have a conversation about some legal issues.
I need to talk to the lawyers. Miss Lewis is still standing. So they had been at sidebar for a pretty good bit of time. And they end the sidebar with Lewis getting frustrated that Bloodworth started speaking, is what it seemed like to me. That she was annoyed that Bloodworth started speaking.
Okay. Mr. Bloodworth, if you would please, however the form of it you wanted to admit to the publish to the jury and admit it as an exhibit, would you put that form on?
All right. Sorry, I found the end of the transcript. It was Bloodworth saying, Your Honor, no, that's not, it's just not under the rules of evidence. And Miss Lewis said, every time, how can? And the court said, take a break, go back to your tables for a minute. Then everyone's excused and now we're here.
The screen. So we're all talking about the same thing at the same time.
Your Honor,
She looks
it is
pissed.
there now.
Okay, so it's the zoom in that we're currently looking at, rows 1 through 5.
All right, we can back it out so you can see the whole form.
Is this the page? Is it one page?
It's two pages.
So it did say celebrate. I thought it did.
Please pause.
I'm sorry.
Okay.
Right. So they were talking about this at the bench. The court was talking about the bubbles. And she's like, it says celebrate. And the court's like, we already said we're going to take the celebrate off of it.
You want to, I'm sorry, I don't have control yet. States Exhibit 2-44 is a 2-page exhibit that says Cellbrite Extraction Report at the top, correct?
Correct.
And you'd like to admit
this 2-page extraction report through this witness, not just the content of the text messages and the metadata regarding to, from, whatever.
Your Honor, the state wants to admit the content. Now, I can see the 244 at the top is labeled with Celebrite's branding. You know, if we were to, for example, redact the labeling, that's fine. But the content...
The distinction, I apologize for interrupting you, so I can just provide a little more context for my question.
Excuse me, Your Honor. Apparently it's unacceptable that when you cut the state off in the middle of their argument so that you can clarify what they're saying and you can clarify your question so everybody has a better understanding, it's really just unacceptable that you apologize for interrupting them in the middle of their argument. It's going to end up in a footnote of a motion for new trial. Oh, like it just did.
I can see the 244 at the top is labeled with Celebrite's branding. You know, if we were to, for example, redact the labeling, that's fine. But the content...
The distinction, I apologize for interrupting you, so I can just provide a little more context for my question. The distinction I'm drawing is the previous photographs. We admitted just the photographs.
Yes.
Not the report from which the photographs were derived.
Correct.
Here, it seems we're doing something, the state is proposing to do something different. That is, admit the report, not just the content. That is the photographs in my analogy.
That is correct, but the state proceeded to just admit the thumbnails as photographs simply to keep things moving along, not because the state thinks that the report is inadmissible. The state just didn't want to bog down in this discussion.
May we do the same now, understanding that the state's ultimately, as I understand your position at Sidebar, going to be, we have another witness that's going to get this report and many others in.
Yes, Your Honor. That is why I think the way we can do that is to just redact the heading. And that leaves us with nothing but content without identifying the source of the content, but Ms. Lauber has already authenticated the content itself.
Ms. Lewis, if you'd put your position on the record.
On the record, Your Honor, this is a Cellbrite report that has not been admitted. We don't have testimony as to how it was extracted. We don't have testimony as to what it is, and it's not authenticated. That can come in through a later witness, I agree. That witness probably should have been called first, but was not. You're right that now we're doing something different than we did on the prior report. And I don't think...
And you heard what the prosecution said on the prior report. The prosecution said we weren't trying to fight it because we were trying to just move along. The state said, excuse me, Your Honor, I have been picking my battles, and that's now bitten me in the ass. I was picking my battles so that we could all just move along. And now the defense is like, no way. So she is trying to restate her position that none of it can visually come in because it says Celebrite at the top.
Just extracting Celebrite, the word Celebrite, solves the problem. You ruled from the bench just a minute ago that this could be used as an impeachment document.
I did not.
Oh, that's absolutely wrong. Now that we've read it, the court did not say. What did the court say, everybody? Chat, we just did that. Chat, that's in fact not correct. At the sidebar, the court said if it can't come in, then it can't come in for impeachment. It can't. That's exactly the opposite of what the court said. OMG.
Have testimony as to what it is, and it's not authenticated. That can come in through a later witness, I agree. That witness probably should have been called first, but was not. You're right that now we're doing something different than we did on the prior report. And I don't think just extracting Celebrite, the word Celebrite, solves the problem. You ruled from the bench just a minute ago that this could be used as an impeachment document.
I did not. I said specifically you cannot use it if it's not admissible because there's no foundation for it.
Well, then we discussed it further, and you said go ahead and show it to her and ask her if she remembers it, and then the text.
That was not in the context of impeachment. That was in the context of the Mr. Bloodworth and his direct using it to refresh a recollection of a witness who may not specifically recall the content.
I misspoke. That's what I meant. To use it to refresh her recollection. And you ruled that that would be appropriate. Well, then Mr. Bloodworth attempted to change your ruling, which happens a lot, which is what
Don't
gets
do
me.
that. Please stay
Well, that's what
focused.
gets me frustrated.
Please stay focused.
I think your ruling was
The court didn't rule. That's the thing, Miss Lewis. The court asked the prosecution, can we just do it this way? And then the prosecution started to say, no, we don't want to just do it that way. It wasn't a ruling, it was a question. And the prosecution's answer to the question was no, because you know what the court can't do? The court can't tell the prosecution how to try their case. So the court's like, could we do this? Why? Because the court was trying to streamline it. And Miss Lewis was creating a whirlpool by running around in circles. And the second Bloodworth responded, she's on, and Mr. Bloodworth is changing your ruling. He didn't make a ruling. And that's why the court in context is saying, please don't do that. We are again not focused, which she did the whole time at Sidebar. That whole time at Sidebar, it was, please answer my question. Please talk to me about my hypothetical. Okay, let's use a different hypothetical. Okay, now what is the issue? Dude, this is why I could never be a judge. This is why I could never be a judge. Because this would,
ruled from the bench just a minute ago that this could be used as an impeachment document.
I did not. I said specifically you cannot use it if it's not admissible because there's no foundation for it.
Well, then we discussed it further, and you said go ahead and show it to her and ask her if she remembers it, and then the text.
That was not in the context of impeachment. That was in the context of the Mr. Bloodworth and his direct using it to refresh a recollection of a witness who may not specifically recall the content.
I misspoke. That's what I meant. To use it to refresh her recollection. And you ruled that that would be appropriate. Well, then Mr. Bloodworth attempted to change your ruling, which happens a lot, which is what
Don't do
gets
that.
me.
Please stay
Well, that's what
focused.
gets me frustrated.
Please stay focused.
I think your ruling was appropriate, that it can be used to refresh her recollection.
Your Honor, you were agreeing with us. We liked it when you agreed with us. I interpreted your ruling as letting me do what I wanted. Why are you not letting me do what I want?
We discussed this, you ruled, and I think your ruling should stand.
You understand that this will limit your use of this document in impeachment?
That's fine.
Okay. Will there any further record?
Yes, Your Honor. To use the photograph analogy.
What is this? What is this not? Look at the faces between Lewis and Kouri over here. Again, if I was looking at the bench and looking at the two of them, I'd be like, seriously? This is why I've opted not to be a judge. Because my judicial comportment would be more like a very angry referee throwing red cards, not saying, please pause. That's not what I said. Because what judges can't do is say, counsel, be so for real right now. Are you fucking kidding me? Nope.
Will there any further record?
Yes, Your Honor.
Look at them.
To use the photograph analogy.
Lewis said something to Kouri because Kouri's not looking at Lewis. Now I'm just watching the interaction between the two of them. Kouri's not looking at Lewis. And Lewis says something to Kouri. And Kouri looks at her and then starts to kind of chuckle.
Okay. Will there any further record?
Yes, Your Honor. To use the photograph analogy. It doesn't matter who took the photograph. if somebody was there to observe the content of the photograph,
Then you can say, look at
they
this
can impeach.
photograph.
Or they can authenticate it.
Correct.
That is what we have here. Carmen Lava was a participant in this text message exchange. She can authenticate it.
Yeah, she definitely turned her back on
And that is the
Bloodworth.
only substance in this report. She has authenticated 100% of the substance of
The
this
text
report.
conversations. Right.
Are you comfortable presenting it to her as, this is a document?
Yeah.
Does this document match your
Also, do you remember when the defense was trying to present just screenshots of text conversations? They weren't presenting who took the screenshots. They were just saying, is this your text conversation? Right.
recollection of text messages you had with this person on this day?
Your Honor, not only am I comfortable with it, that is precisely what I did when I had her authenticated.
Okay.
And how it was extracted
Oh, she's not even
doesn't
listening.
matter. That is when you don't have a witness.
Lewis is having a whole side conversation now with Ramos. For those of you listening in the background, she's not listening to Bloodworth at all.
With it. That is precisely what I did when I had her authenticated.
Okay.
And how it was extracted doesn't matter. That is when you don't have a witness who was present to authenticate it.
I understand.
Which is then the problem that they got into with O'Driscoll. Because they tried to do this exactly with O'Driscoll, but O'Driscoll wasn't a party to the text conversations. This is exactly what they tried to do days later.
Okay.
I hear you saying if you had a screen grab of text of bubbles from a phone and her testimony was the same, like, I remember this,
Yes.
I remember this exchange on this day at this time, you would seek to admit the bubble as a document that she laid foundation for.
Correct.
For the bubble.
Regardless of who took the screenshot of the bubbles. Right here, Celebrate took the screenshot of the bubbles. Doesn't matter.
I understand the state's position. Ms. Lewis, anything further?
No, Your Honor.
Okay. So,
Miss Lewis, are you wearing Lincoln Park After Dark? That's really my only question, because I do like Miss Lewis's nail polish. But I'm also waiting for Miss Lewis to start like stomping her foot, because her whole demeanor right now is that she's a hair's breadth away from literally stomping her foot in frustration in court. She's so mad. She's so mad.
the defense has a thought-provoking argument that including all the stuff in the header gives this document some imprimatur of
Emily, you just want to hear Judge M talk more with the... Yeah, I do. I just want to hear Judge M talk more. Also, fantastic use of imprimatur. Look, the judge is saying having the header that says Celebrate makes it seem more official. She can't testify to all the official shit up at the top. Like, that's not her shit. She can only testify to the bubbles. Perfect.
technical proficiency or additional weight regarding which this witness has not laid foundation. So,
Redacted. Just cut it off the top.
State's Exhibit 2-40.
The court's like, hey, can you guys just splice this like Kouri's bank records for me? Cool.
4.
All right. So with that, we have gotten through the 2 sidebars that are in the very first footnotes of the defense's motion for new trial. I really very much wanted to see the context of Nestor being told to slow your roll. And I really wanted to see what led up to this whole exchange where Lewis is saying that the court was being horribly biased and horribly rude and apologized to the prosecution when interrupting. Maybe it's because the prosecution literally never got a word in edgewise at sidebar, and the prosecution had never actually gotten to make the rest of their argument. And then as the prosecution finally had the opportunity to make their argument, the court interrupted them. And so how would I have dealt with that? Less good. Bloodworth is just like, we can just wait all day. Go ahead and run in circles. It really is the energy of Bloodworth watching the defense spin themselves in circles, being like, I mean, eventually you're going to get tired. So we'll just wait. Well, y'all have the zoomies over there. We're just gonna chill, and we'll wait till you get it all out of your system. You done now? Great. And so with that, we can see a little bit more fulsomely why the presiding judge or the associate presiding judge of the 3rd District looked at all of this and said, no, there is no evidence on the record here to show that Judge Mrazek was biased in the way that would require him to be removed from the case. Now, remember, we have not seen the argument on the motion for new trial. We have not seen the state's response to it. We won't see that until September because, well, when they were setting the dates and the defense was asking for more time, the prosecution was like, so when we planned everything after this trial, we accounted for time to file based on the original timelines. And if you're giving the defense more time, the people have vacation, which is laudable. Everyone needs a break. Especially when you exercise that amount of patience during trial. I think a break is definitely needed, but the prosecution's not going to respond until September. So today, when court ended up being as short as it was, I really wanted to take a look at those 2 sidebars. I will take a little time and look and see if there are other sidebars that may not be brought up in the defense's motion that may have been heated exchanges during trial that I want to go take a look at while we were in trial. And I take handwritten notes during trial, but while we were in trial, there are times where I will note if something is going on that I want to go look back on. So I need to go back through my notes and take a look at that. But we have the trial transcripts now, and that gives us the opportunity to go back and look at some of these sidebars. But trying to picture Judge M say, slow your roll was too much for me. I was very, very interested to see it. So with all of that, Emily, where do you think we're going to get with this defense motion? And for those of you that haven't seen me go through this motion in its entirety, I will put the link to that video down below because it's a lot. Spending most of your motion, and they spent the majority of their motion arguing that the judge was unfair. I do not think that is going to, I don't think that's going to go anywhere for them. I think it is a wild choice. I think it is going to fail spectacularly. I think that down the road, we will see an appellate attorney argue that they didn't make the motion to disqualify correctly. The legal grounds of too much evidence of financial crimes coming in, I don't think are sufficient because this is an aggravated murder, the aggravator being pecuniary gain. So when you have an aggravated murder for pecuniary gain, evidence of the pecuniary gain has to come in, and it's appropriate to do so. You can bring in other evidence of other things that were done, but there is a balance to that, and we saw that balance in the Murdaugh case. And then in this case, the defense team said, and Alec Murdaugh's case was overturned for that, which again, incorrect. You are so very, very wrong. The court had some statements in dicta about the financial evidence and about the fact that it can be valid to come in, but there's a balance there. And that not all of the Supreme Court of South Carolina agreed on that balance in the Murdaugh case. So the court issued thoughts. They had their thoughts, just some thoughts about maybe it being too much in the Murdaugh case. And the reason it was too much in the Murdaugh case was not the volume of evidence that came in. That might be a caveat of it, but it was how sympathetic some of that evidence was. And we went through all of that. So where does that leave us? Well, I'll see if we have some more sidebars. We are not going to see Kouri Richins back in court on the restitution hearing until the end of August. We will not see her back in court on the financial crimes case for quite a while. Kouri Richins has a hearing in the civil case coming up in October. So the next thing we will probably see in the Richins case, I mean, then again, anything can happen, but the next thing we will probably see in the Richins case is the state's response to the motion for new trial. And that will be at the beginning of September. So where will we go when EDB gets back from a break? Well, I'm sure much will happen between now and then, but we will be taking a look at, well, everything we need to catch up with. There is a lot happening in some of the Massachusetts cases, but we have spent so much time in Massachusetts that it was nice to visit some of the rest of our country for a moment. And I was really surprised by the fact that there was a ruling on the motion to disqualify, or the attempted motion to disqualify this week. I was incredibly surprised by the Koberger stuff. I'm sure there was going to be more in the Koberger case coming up. And so with all of that, we've got to get to questions. You've got questions. I've got questions. We've all got questions, and we'll get there. So we will see. Oh, Kate P, this is a great point. Also, adorable pupper. Kate P said, didn't this trial also include insurance fraud and forgery too? Yes, it did. It did. It included both. Yes. It also goes directly to the charges. Also, I think that the court limited a tremendous amount of it. Let's get to questions, shall we? You've got questions. I've got questions. We're going to chat real quick. Let's chat. And then EDB has a very, very busy week. It's going to be great. It's going to be great. Are we prepared? No, but it's fine. It's happening. It's going to happen. So I will be on break to go see my kid perform. If weather cooperates, I should get to see him perform Lost Boys 4 more times before the season is over. It doesn't feel like enough. I love this show. I love his performance in it. I love seeing him perform. I'm going to get all emo talking about it. I'm really excited. It's just different. Like getting to watch your kiddo just do something that they love is just incredible. It's still weird to see my kid on like NFL fields. That's still a little surreal to me, but I absolutely love it. I can't imagine how parents of, like Olympians and stuff feel like watching their kids in those. I imagine it's probably the same, but I'm super emo about it. So I am going to be off doing that. I will be sharing that in the Lawnerd Lounge. I will share updates if like things happen in cases and I'm like, hey guys, just a quick update. I will pop in and always let you guys know in the app what that is before I post it anywhere else. I will be posting some behind the scenes, I'm sure, on Instagram. But I've shared before a little bit of our turnaround, not just mine, but we have finals in Indianapolis, which is going to be great. And then after finals, we have a 1-day turnaround to get Travis moved into college. So we have, we're getting back to Tennessee after finals, probably early in the morning on Sunday. And then we leave very early for a road trip Monday morning to get him moved into college on Monday. So it's all going to be fine. So Travis has 24 hours to wash it. Well, for us to wash his stuff from tour, there is nothing quite like the smell of a tour suitcase after tour, but that's going to be great. We have a window to do laundry from tour, and his room right now is largely in IKEA bags, so we can throw the IKEA bags into the back of the vehicle and move him into school, and then do some grocery shopping since he's moving in for band, and the dining halls aren't open yet. It's going to be fantastic. It's going to be fantastic. I can't believe it's happening. I can't believe it's happening. Rena said, try a hockey bag. So yes, the hockey bag is same. I have friends who had kids who played hockey. It's about the same. It's the tour bags. It's about the same, except the hockey bag doesn't have the AstroTurf smell and the little pebbles of the AstroTurf. The turf smell gets in there too. It's crazy. But yeah, it's about a hockey bag. Lori said, that's all this week. Yeah, that's all this weekend. That's all this weekend. That's all this weekend. It's going to be great. It's just a lot. But also things are moving so fast. There's no time to like pause. Judge Adams is going to be like, pause. There's no time. Finals are going to be great. I'm excited to see how it goes. Somebody had asked earlier, and we're going to get to questions. Somebody had asked earlier about the scoring for DCI. I have many, many thoughts. But I do like the DCI organization, and I would like them to continue to like me. So I am going to pause on that. I will share, and for those of you that are here at the very end, you will know, and we'll see, others will discover later. But if you are watching finals this weekend on Flow Marching, you will probably see some of EDB, because I did record stuff for finals with Flow Marching. So you will see that on Flow. We have a discount that is linked below if you want it. Beginner Crafter said colleges start so early in the US. Some, not all. Travis is moving in early because he is in band. So he is moving in ahead of classes starting because he has band, and that happens. Dash said, do you get discounted finals tickets with being a parent? No. I'm sure there are early group sale tickets. Like there's a discount for buying them early, I believe. But I'm ADHD, so there's that. But they have like, I think, an early purchase discount. Emily, you don't purchase early? I don't, because I'm not sure exactly which side of the field my kid's going to be on. And I do not always need to sit at the 50. I am happy sitting off, but I don't know which side I need to be on. So I kind of wait because I want to see what side of the field he's predominantly going to be on. Or for those of you asking what instrument, he is in color guard. So he spins things, weapons, clock hands, flags. It's just awesome. So Tony said, DCI and discount are two words that don't know each other. That's very fair. Also, the finals always sell out, and it just always sells out. But he is moving into school a bit early. I am excited, as I was putting some of his school calendar into our calendar, that he does get a little more than a month off during the winter, though I imagine he's going to have winter guard practice. So we'll see. I loved being at college when classes weren't in. I absolutely loved it. I loved being at school when everybody else was gone. There was something that felt awesome about it when I was there for water polo or for what have you. I loved it. So I'm sure he'll enjoy being on campus a little bit when everybody's not there. And coming off of tour, I'm sure he's going to need some days where he gets to sleep before band practice. Julie said, isn't Allentown this weekend? Allentown is this weekend, which I think starts today. I don't know if, hold on. I don't remember which day Cavaliers perform. Hold on. They might perform today. I haven't had a chance to even look. Let's see. DCI Eastern Classic Day 1. They perform tomorrow? Let's see. Yeah, I think they perform tomorrow, actually. Because today for Friday night is Troopers, and I'm starting after intermission. Troopers, Spirit of Atlanta, Blue Knights, Blue Stars, Colts, Blue Coats, Blue Devils. Okay, so today's blue. If you are team blue, blue is today. Because today is Blue Devils, Blue Knights, Blue Coats, Blue Devils, Blue Knights, and Blue Stars. If your team starts with blue, today's the day. If your team not with blue, tomorrow's your day. So tomorrow's your day is what we'll see. I saw a couple of you ask about Dr. B. Dr. B is doing well. He is feeling much better. Band is doing better. And that is really exciting. So, and I will be sharing just all band all the time. Also, if you are a member on YouTube or a member in the Law Nerd Lounge, we will be doing a members only on Tuesday. I am not sure exactly what time yet, but I will let you know. It will be during the day on Tuesday. I will not be streaming otherwise on Tuesday, but we will have a members only. We have some behind the scenes stuff to talk about. We have some band stuff to do. We will watch some band stuff together. We'll talk about some other stuff. It will be a members only. Also, one of you amazing law nerds, I don't know where it went. Oh, it's outside of arm's reach. One of you amazing law nerds have already sent me some Mad Libs. So there will probably be some Mad Libs. Joseph said EDB takes the fifth on DCI. I'm too biased as a parent, but I do explain how the scoring works for the Flow Marching Finals show. So I do explain how the scoring works. I will say with performing arts, it is always very difficult. And as a parent, my opinions on scoring start something like this. I love my child's core and my child the most. And everything is skewed through that perspective. So I just keep the rest of it to myself. Also, I am kind of useless when it comes to like brass and percussion scoring because my level of technical knowledge, particularly with brass, is low. And B, I go by vibes. I was like, that sounded cool. That sounds good. Ooh, that doesn't sound so good. Vibes. So I'm not the one. I am not the one. I am not the one for it. But I also know that, so it's perfect. A couple of you are asking where T is going to school. He hasn't shared that yet. So when he does, I will, but he hasn't shared that yet. So I kind of follow his comfort level on that. And I'm sure at some point he will choose to, but until he does, I follow his lead. Because also there was a while there where he wasn't sure if he wanted to share that he was marching Cavaliers or not. And then he was like, no, I want to share that I'm marching Cavaliers. And I'm like, perfect. Can we share with the law nerds? He's like, yeah, that would be great. And so I really follow his lead on that. So we'll see. But yeah, if and when he wants to share, we may. So it is, he's going out of state. He is not going to be at UTK. That is the most natural question to ask. Is he going to UTK? He is not going to UTK. Most of his friends are going to UTK. Most of the people, quite a substantial amount of people he graduated with, are going to UTK. He's very excited about the programs at the school he is attending. And honestly, I think some of it was also vibes. He loved the campus. It just felt like a right fit, and it felt like a right fit with the band programs as well. So sometimes you just have to visit campuses and feel like a vibe. And we visited UTK. UTK is beautiful, but we visited UTK and he was just like, well, this is a lot. It's a beautiful school, just a beautiful school, but it is massive. UT Knoxville. So the K in UTK is UT Knoxville. Though I am not a native Tennessean, I know most Tennesseans would just say UT because the other UT came second. And so our UT is apparently the first UT and the other UT is like not the OG UT. I don't know. It's not my fight. Look, man, I grew up with like UCLA, USC beef. I did not grow up with which UT came first. So he is not attending either of our alma maters. So, but yeah, the vibes are right. And one of the things I really enjoy about T, I think it's clear that I enjoy my kids very much, but one of the things I really enjoy about T is that he has never been afraid to find the thing that works best for him. It doesn't matter what everyone else is doing. It doesn't matter what everybody else wants to do. It doesn't matter if people are going to understand it, not understand it, vibe with it, not vibe with it. He's like, I want to do this. This is the right fit for me. And I love that. And his path to college was part of it. I will tell you a funny story about that. We had been talking about applications. We had been talking about schools. We had visited schools. And I told him when we visited schools, I'm like, look, there are some schools you might not be interested in, but you can't know till you know. And so I want you to like step on to multiple college campuses, walk around, spend some time and see what you think. And he goes, yeah, I don't know if I'm interested in this school. One of them was in Florida. We were traveling to go see My Chemical Romance. And he's like, I'm not really interested. I'm like, that's fine. But we have some time before the show. And I want you to just vibe on what some other school experiences are like, even though you think you want to go to this school. And he's like, I understand. I'm like, great. You understand? I understand. And so we had gone to a number of schools, even if they weren't ones he was necessarily interested in. And so I was traveling, and this, depending on who your kiddo is, this might be a different experience for everyone. And he sent me a text message the night before. He's like, hey, I finished my application for school choice number 1, which is where he's going. I filled out my application for school choice number 1. And I'm like, what? And he's like, yeah, I filled out my application. I'm like, huh? What do you mean you're done? What do you mean you're done with your college application? Done with this college application. Filled out my application. Done. I'm like, so you didn't need anything? He's like, no. I'm like, okay. I am sitting on a plane in New York, getting ready to take off. My phone is not yet in airplane mode. They hadn't told us to look. I was not playing Words with Friends, and they hadn't told us that our phones needed to be in airplane mode yet. So I am not in airplane mode, and T texts me and is like, you busy? And I'm like, I mean, I'm on a plane. Like, I think I sent him a photo of me on a plane. Like, not really. I'm on a plane. We're taking off. Like, we're wheels up in like 10, but hit me. Sends me a screenshot of his acceptance letter. And I'm like, did you apply for early admissions? What? Huh? Sends me a screenshot of his acceptance letter. And I'm like, what do you mean? And he's like, so I got in. I was like, I mean, I'm not surprised, but okay. You got a minute? Send me his acceptance letter. I'm like, okay. Congratulations, buddy. I will be home this evening. I would love to celebrate. And that's fantastic. Also, you need to finish your other applications. He's like, I don't know if I want to do all that. I'm like, you need to just finish a few other applications, Travis, in case you change your mind between now and the time you leave for college. You never know. You might change. Child, just finish a few other applications. Just learning how to apply for things and pay attention to detail is also important. But he was just like, I got in. And this is my kiddo. I'm excited for him. It is going to be an adventure. I am not ready for him to be gone all summer and then turn around and be gone again. But I'm excited for him. I'm excited for the next chapter. I'm also excited for him to have a minute to come home and get some break get a break, because he's just going to be like going and going and going and going. So yeah, but I also appreciate that he's just like, this is what I want to do. Okay. Get it. Love that. So that's where we're at. That's where we're at over the next 7 days at Household Baker. 4 DCI shows, multiple 6 to 10 hour drives, at least 4+ stops at Buc-ee's, and probably too much Dr. Pepper. That's what we're doing. And it's going to be very, very interesting. AR said, happy Friday from hospital, hopefully home today. AR, I hope so too. It's always so much better to be back in your own home. Recover well. I hope that you are home soon too. I love it. Before the Grave said, I went to DCI in Mass. I don't understand the scoring. Crusaders were phenomenal with no real props. Phantom was sick, but Bluecoats were just chaos. it is fair enough. These shows, look, first of all, the general effect scores and the music scores are different. Also, the way that judges who watch shows all the time score them and the way that the audience who watches shows less frequently score them are different. I love a show that's approachable. Other cores love shows that are conceptual. I think Boston's show is fantastic this year. I think it's been underscored. I think Phantom has been underscored this year. Someone will probably tell me that somebody's horns and or perk and or general effect is not doing whatever. I'm very much vibes when it comes to DCI. And when I watch a show, I'm just like, I loved that. Or I watch a show and I'm like, I need to watch that again. I don't quite get it. Or I'm like, that was sick. Or I don't love that. So for me, lots of vibes. Lots of vibes. But it's valid. It's also valid to look at it and be like, I don't quite get that show. That's fair. I haven't seen Blue Coat's show this year, but I'm obsessed with their post-show encore. Have y'all seen their post-show encore? Hold on. I might need to just cue it up. I might just need to cue it up again. Yeah, I might just need to cue it up again. Because I'm obsessed with it. And maybe we'll do that as a cleanse for the end of... Emily, we're not ending on Cavaliers. No, we're going to watch Cavaliers on Tuesday. We're going to go through the whole show. I've got the whole show to go through. We're going to go through the whole show together. And I can't wait. Let's see. I think G just gave you a great merch idea. I mean, the skill issue. If you're good at fraud, you don't get caught. If you're good at life, you don't need fraud. It's fair. It's absolutely fair. Let's see. Will the murder be able to be mentioned in the fraud trial? It's going to be interesting to see how they navigate it, but part of it will come up because some of it goes to motive, but it will be interesting to see how they navigate that if it goes to trial, truly. Julia said, no place I'd rather hang out today. Same, Julia. I love seeing the Lawnards. Shell, thank you so much for the 50 gifted memberships. We have lots of new members. So Tuesday, new members, we will be back for members only. So do not worry. I hear Photograph in my head by Nickelback. Same. Cons the Dog said, I can't believe how much fraud Kouri committed. I mean, she was speed running some fraud for sure. Just lots and lots and lots and lots. Joe said, my oldest grand girlie is 17 today and taking her driver's test. Grandma is all in her feelings. Yeah. I can't imagine when I can't imagine that on like the flip side as a grandparent, because I know how emo I was about it as a parent. Like, it's like, but they're the babies. What do you mean you're driving? It's crazy. Insomnia Petals, thank you for the 5 gifted memberships. Chat Mom Lynn, I don't know. That was going Lynn and Lane. Best 30 months ever. It's always great being here with the Law Nerds. I saw some questions about the murder case in the fraud case. It will be interesting to see how they navigate it, because there are some caveats and considerations, because you don't want the jury to be like, well, if she's a murderer, obviously she would commit fraud, but they are interconnected, but there are cautions there. And this judge has shown himself to be quite cautious, but that's if this goes to trial. I just don't know if it will. Lori said Judge M told the jurors after that fentanyl was found in the house. I think I remember that, because I remember that he was like, ask me anything to the jurors. And there were things that were presumptively tested positive for fentanyl. I remember that. But yeah, some of it just got kept out. There's a lot more evidence in this case that didn't make it into court. And that is part of the strategy of trial for both sides. And that's a lot. It is. Linda said Lewis's argument is so painfully obtuse. It's one of the things that I would struggle with this group of lawyers is the circular reasoning. And it would be hard for me as a prosecutor to be as composed as Bloodworth was, because there would be a part of me in my soul that would be like, Your Honor, they're doing it again. Make them stop. And also the ADHD is the circular reasoning. It is so hard for me not to interrupt and be like, stop it. You were just saying this and now you're saying this. Which one is it? It would be a struggle bus for me. Though I have broken my like work mode, court mode so thoroughly that it would be very hard to fit myself back into that box. Like we've broken completely. My face didn't then either, because the court, different judges would look at me and be like, Miss Baker, your face. I'm like, I know that my face is facing, but there's no jury here. I did get in a wee bit of trouble when a defense attorney was doing a full circular argument and I started laughing out loud at counsel table. It was not my finest moment. It was not the most professional. It was very much the ADHD. I was so exhausted. I just started laughing and the defense attorney got so fucking pissed. And the court was just like, Miss Baker. And I'm like, Your Honor, it is a very inappropriate time to laugh. However, my entire soul is trying to escape my body through laughter. I can't do this anymore. You're draining my will to live. I'm so sorry. I am trying very hard, but once you start laughing, it is very hard to stop laughing. The defense attorney was so pissed about it, and that made it even funnier because then the defense attorney was just getting more and more agitated after being so just all of it, and that made it worse. And I was like, I'm so sorry. But objectively though, this is so ridiculous. Like, this is so ridiculous. Also, it was during a preliminary hearing, so all of the fighting over all of the things was so extra that it was just, what are we doing? That defense attorney, almost every time I saw him after that, was like, so you're going to laugh at me today? I'm like, I mean, it depends what you do. I don't intend to, but that sometimes I just, I can't help it. I didn't throw papers though, but no, that was not in front of a jury. Which is that would have been a problem. I've never actually laughed at counsel in front of the jury. I've laughed with witnesses when witnesses have chuckled. But yes, it depends on you. Please don't. We'll see. H Joy in the chat said, EDB, what would you say is the best way to study or prep for the LSAT? Seriously, researching law schools, and that's my first big step. It really, really, really depends on how you retain information best. So, overthinking is the LSAT has changed so much since I took it because I have many years of experience. So the LSAT has changed since I've taken it. I would try to approach the LSAT, and this might sound very strange, but I would try to approach the LSAT as more of a game of like, spot the issue, spot the answer, and not overthink. It's just, if you can kind of gamify it and take the stress off of it, like, hey, this is a curious intellectual challenge. This exam is kind of weird. Let's see if we can figure out how the exam works. Figure out how the exam works and how the questions work so you don't overthink them. And then take care of yourself so that your brain can actually retain the information and then do that on the test day. I would take lots and lots and lots of practice tests in kind of a test environment, but I wouldn't do that first. If you want to take a practice test with music on, perfect. If you just get the practice test down so you can practice not overthinking the questions, because that's one of the struggles on the LSAT, and try to figure out how you work and how the test works and have fun. But when it comes to test taking, you have to sleep. Your brain puts the information into long-term storage when you sleep. You have to sleep, you have to eat, you have to hydrate, you have to move. If you learn really well by listening to things, find everything you can on audio and just listen to it while you're doing other stuff. If you learn really well by drawing it out, get a whiteboard, draw it all out. You can study however works best for you, But remember, that test is more of a test in taking the test than a test in the knowledge that's on the test. So if you figure out kind of the game mechanics of the test, I think it'll be a little easier if you tackle a problem where you don't exactly know the answer. If you know the mechanics of the test, it makes it easier to be like, well, it's going to be one of those two. Let's see how it goes. It'll be great. And try not to overstress it. The more pressure you put on it, the harder it is. It's like the harder you hold on to something, the worse it gets. Try not to put too much pressure on it and be like, oh, try to make it a little funsies. And if you can use real world scenarios from the stuff we've covered, like my photograph analogy here, try to find the real world thing. Like, oh, that's like this circumstance. It'll help you remember. Amber Crime Time Angel said, EDB, I think you should do a parenting class. I don't know about that. 2, how did you survive early teens driving mean friends? Driving stressed me out. I reminded my child very much that I trusted him and I didn't trust everyone else on the road. And I hoped that he would behave the same way. And I said, look, I trust you. I don't trust everyone else on the road. I also don't trust all of the wildlife. So I need you to just please be careful. Like, I'm in the car with you, be careful. And also, if anything happens, just call us. I don't care what it is. I don't care what happened. I don't care why it happened. Just call us. We'll sort out the who, what, where, when, why. Travis was in a car accident with a friend. We didn't talk about this a lot because his concussion was a lot and it was very, very stressful. But his friend was driving. They were in a car accident. It wasn't in any way their fault. They were rear-ended. But I was so glad that something I was terrified of happened. But the first thing he did was call me. And when he called, he said, Mom, I'm okay, but I need to tell you that we were in a car accident. And I'm like, thank you for leading with Mom, I'm okay. He's like, I don't know what we're supposed to do. And I'm like, great. So is your friend okay? Have the cars stopped? Is the other party still there? Is everyone okay enough? He's like, nobody's bleeding. I'm like, great. You or your friend need to call the police. You need to take pictures of the vehicles. You need to make sure that you are in a safe space, and then gave him the information. But I love that he knew that he could call without me asking him a million questions that he wasn't ready to answer just then, other than, okay, so is everyone okay enough? Are you safe? Okay, now let's do the practical, because it's scary. And so really my best parenting advice is take care of yourself. It really is as simple as like, you have to put on your own oxygen mask first, but take care of yourself so that you can roll with it. And even when you are scared, mad, especially that like scared mad, like when they're really little and they like run out in the parking lot or something, that scared mad is a hard feeling to rein in. And trying to rein that in is you doing the work as a parent. And then sometimes it's okay to just be like, we're going to deal with the child. We're going to get the child to bed. Spouse and I are going to talk about all of this shit and be on the same page. With friends, I tried not to give too much input. I also knew how my teen worked. My teen was much more chatty after about 9 p.m. So I tried to be available after about 9 p.m. And just, I would be like, hey, I'm just wrapping up work stuff. I'm sitting here reading. So he could just drop by and plop on the couch and then be like, what are you working on? It was never, what are you working on? I would tell him a little bit and he's like, so this. So just as they're teens, it's not really starting the conversation, at least with my kid. And other parents in the chat, please chime in on this. I would love to hear what you think. For me, it wasn't necessarily starting the conversations. It was being around so that he could start the conversations. And then if he asked for advice, chatting it out with him, but trying to let him come to his own answers because he has to figure out how to navigate it. So I really found myself as more of the, tell me what's going on and let's talk it through. And how do you feel? Does that make you trust that friend more or trust that friend less? Okay, so what do you want to do? Do you want to see how it goes? Do you want to not talk to them for a minute? Like, what do you want to do? What do we want to do with that? Because you have options, but you're right. And then validating their feelings. Like, you're right. And just finding that time to be available, even if they're doing other stuff and you're just kind of around, they will pick up that time to talk. And it really also depends on your kid. And then if you reach a circumstance where you need help, it's also okay to tap in other adults, whether it is therapists, people in your community, coaches, or other adults. It's okay sometime to just tap in with other adults and be like, you know what? This might be a great conversation for your aunt, for your uncle, for another adult that you trust, and let them get somebody else's perspective too, and remind them that they can. So I've really found, especially when you get to about the junior high, it's about them trusting you to tell you the things that are going on and trusting that you're not going to freak out on them, even if internally you want to freak out on them. Because if you freak out on them, they will stop talking. If you freak out later, they won't know. And it's not that they need to trust you. It's not that you need to trust them as much as they need to trust you. So they need to trust you. And show them that they can do that, and let them know repeatedly, you can bring me anything and we will figure it out. Even if I don't like it, even if it's not a good decision, even if I don't agree, we will figure it out. But I can't help you figure it out if you don't tell me. And then you hope for the best, because I hope for the best, because I hope for the best. So, and then, the more you feed them, the more their friends will come around. It's kind of like the wild turkeys. The more you feed them, the more their friends will come around. And I find that to be helpful too. It's like, we have food. And encourage them to get out in real life with their people, because this generation seems to be struggling with that. So it's a lot of parenting is kind of parenting yourself, really, so that you can just breathe. It's hard. It's not always easy. It's not always perfect. They know when you're trying. Truly, they know when you're trying. And there's been times this tour where Trav called kind of late, and he's like, Mom, you're up. He does not need to know if I was not up and heard the phone ring and answered it. He does not need to be aware. He does not need to be aware. Mom, you're up. I'm up. Also, I'm kind of a night owl. Mom, you're up. I'm up. What do you need? What's going on, buddy? I had a minute. Great. So you've got this, law nerds. I know it's not easy, but we've got it. We've got it. We've got it. We can breathe, and then we can talk about it with our friends and our spouses and everyone else, because we've got this and you've got it. And look, your kids know when you're trying. They really, really do. And it can be hard to know that you're doing enough. If your kids talk to you, you're doing enough. Truly, if your kids are talking to you, you're doing enough. T has shared with me stuff that some of his friends have struggled with. I've talked to friends about their kids and their kids' friends group. And if you talk to your kids about their friends and their friend group, there are a lot of adults who are just not at bandwidth to even be present. You are doing a good job. You are doing a good job. And they have to learn on their own. And that is really hard when it feels like the stakes are high. And talk to them a lot about social media and that the internet is forever. Amen. It's the end of that. Because you just have to, you have to also, the other thing that's hard for me, is that not getting caught up in what other people are doing can be hard too. Like I should do more. There is a lot more I want to do for Travis. There's a lot more I want to do for like Travis's dorm and move in and what have you. But I also don't want to overstep his decisions and his agency and autonomy to make those choices for himself, especially because he's on tour and we can't do it together. So there's a lot of things I would like to do, but he's going to get to make those decisions. And so it is my job to sit on my hands and kind of step out of the way and be like, you have bedding, you have towels, You will have food. You have your clothes. You have your technology. You have chargers. You have a fan. It's going to be fine. Would I like to do more? Yes, I would. Do I need to do more? I feel like I do. But that's me. He is going to be like, oh, great. I've been living on a bus with a fuck ton of guys for the entirety of the summer. This dorm smells lovely. I have my own shower and the water's hot and there's doors on the bathroom. This is fantastic. I have my own bed. This is great. Like coming off a tour, he's going to be like, I'm set. I need nothing. I'm very extra. Travis is very minimal. So I get to step back and just be like, Amazon exists. If you need something, let me know. This is fantastic. Cheryl Ray in the chat said, I learned to ask what response is needed. Am I listening or am I fixing? It's incredibly true. That works in almost all relationships too. 100%. Just 100%. Yeah, exactly. He has an actual shower. Travis is going to be thrilled. He's like, I got everything I need. He's going to need some new toothpaste and stuff. And that's about it. But he's good. So listening or fixing is really helpful. And sometimes I'm like, Trav, do you just need a hug? Like I'm here for just a hug. And then there's times too with both of my kids where I can tell they're upset. It's like, I can see something's going on. Do you need to talk? Do you need a hug or do you need a minute? And I'll respect any of those. Just let me know what you need. And sometimes they need a minute. Sometimes they need a hug. Sometimes they need to talk. Sometimes they don't want to talk. And that's okay too. So all of the things. What else? So Lawnards, that's where we're at. It's going to be fine. But yes, also trying to step back on like, it's going to be fine. Yes, we absolutely have like a wellness kit because he's also coming off of tour. And so I can see him being under the weather for like the first 3 weeks because he's just coming off a tour. But yes, 100%. And what's nice though is the band that he is joining has a lot of other band members that are also on tour. So I think it'll be really interesting for him to get to go back to school, but get to go to school. But then he's also going to be around people who are also coming off of the exact same experience with a bunch of different cores. And I think that's going to be really cool too. So I'm excited for him because he has some people who are going through the exact same experience and who are also further ahead in college than he is, who can also help him navigate that experience. I think it's going to be great because that post-tour month or so is going to be much. And I'm glad there's other marching members who are going to be there to navigate it with him. So it's, yes, deep breaths is where we're at. Deep breaths. It's deep breaths. We're going to be fine. So Lawnards, I will be on break. There will be a podcast Monday. We have some stuff for the Emily Show channel. Tuesday, we will have a members only stream. I will be ish on social. I'm not quite sure. I will be ish on social. I will be making sure that you are updated in the app if anything significant happens. If things are pretty quiet, I will see you when I get back. And I will keep you posted on that. We have some really fun stuff coming for you in August. We have some updates to the app. We have some updates to the Lawnard shop. We will be talking more about how emo I am on Tuesday. I'll let you know after the weekend. I'll let you know how good we are. It's gonna be great. And I will take some photos if I can to share of the dorm move-in and the stuff that, well, if he likes it, I will share the one set of shelves that I purchased. What did you buy for Travis's dorm? I got a set of shelves. What else did I get? Sheets and towels and a boot holder for near their front door because my favorite docks got stolen out of the hallway at UMass because I had worn them to Hobart Hoedown. And so they were disgusting. So I left them outside my dorm to dry and then they got yoinked. I'm still bitter. That was 1997. So I got him a large boot rack so that it was big enough for him and his roommates to put their boots on near their front door. He has a fan. We definitely got him a fan. And then he has other stuff that's in their rooms. So I'm excited. I'm anxious. It's going to be great. It's a lot of driving. It's going to be fantastic. So, Law Nerds, I'm sure there will be lots of court that happens. We will, I will keep you in the loop. Is anything going to get too crazy? Hopefully not. What's going to happen in the Koberger stuff? They might set a hearing date. It's not going to be before I get back, so it'll be fine. There's no trials that I'm covering right now. It'll be fine. And then there are some trials that I'm keeping an eye on for in the fall. So I'm keeping an eye on those because my travel won't be nearly as crazy in the fall. Law Nerds, it's great to see you. I'm glad we got to go to court today. We got to talk about life today. We got to do all the things. Take care of yourselves. Take care of each other. For those of you that are new members, there is a huge back catalog. For those of you that have missed some of the trials on the channel, go find one. I'll be back. I'm not gone forever. Also, if you have not listened to Dungeon Crawler Carl on Audible, and, well, you're here, so the cursing is not going to offend you. Not spicy, but the humor is 10 out of 10. The narration is 10 out of 10. And if you need an audiobook that you are just like, ooh, I would love to dive into a very juicy series that has a lot of books, you might very much enjoy it. Law Nerds, you're the best. I'll see you soon. Take care of yourselves over the next few weeks. Take care of each other. I will be back after move-in. It's going to be all good. Take care. And a huge thank you to Team Baker. And, well, if you're not subscribed to the Emily Show channel, we will have new stuff up there for you, breakdowns of the videos and stuff. And make sure you have the Law Nerd app because that's where I communicate the most, especially when I'm taking a little bit of time off. I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.